I've fallen for this mysterious black woman. Her alluring smile and intoxicating dark skin have set my frozen heart ablaze with burning desire. But I'm a counter-racist hitman. It's my sacred duty to spy on these crooked cops, waiting for the right moment to expose their secrets and end their reign of terror. Now, I'm in love with one of my targets, silently watching her. Gazing into her deep brown eyes, my heart pulses with uncertainty. Is this black woman one of them, or is she with us? How do I manage this love battle waging within my heart while delivering justice to the black community? Find out in War of the Heart, an Occam Jeffers novel, coming December 1st everywhere books are sold. Visit spiritOf1811publishing.com for details.
We only war extraterrestrial level for this petty crime. Too many blind, too many dying, too many times. So now we gotta draw the line, walking alone.
In Washington, D.C., aliens descend upon the city and discover melanin.
This man feels great. This man's essence is incredible. Are all the males on this planet like this?
No, it seems to be only the men with dark and brown skin that have this essence.
They notice the people. They exploit the people.
Why are you doing this to me?
Because I enjoy it. And because I can.
And they learn the ways to get collaborators.
What type of payment do you want?
Do you see me? I have the best. I want the best. And I deserve the best.
Join us for the new drug you can find on YouTube at the Urbangodz, spelled with a Z, channel on YouTube, premiering October 24th.
NormalBrands.com has empowering tees, hoodies, sweaters, electronics, and more with positive, inspiring messages that'll make you stand out anywhere. Check out our collections to see our latest, freshest gear for men, women, and children. All items are buy one, get one 50% off, and each piece is unapologetically unique. Normal Brands. Be you. That's more than enough. Make sure to visit www.normalbrands.com. Once again, that's www.normalbrands.com. All right. All right. I hope you guys can hear me okay out there. Welcome to a early live stream of Nicole's View live on this Tuesday, December 1st. All right. Shout out to everyone in the chat room, everyone that's watching. If you're watching on Twitter, if you're watching on Facebook, I've tried to send out alerts to let people know, tune in and share this. Share this, share this, share this. I have over 60,000 subscribers, apparently. And I want to get as many eyes on this particular live stream more than ever before, okay? I think the most I've ever had is when I had my dear friend Taj Jackson on here. Over 1,000 plus people were tuned in. That was pretty awesome for me. Let's try to get it up there. Not only for this particular live stream, but when I go live at 1 p.m. Central Standard Time, which is 2 p.m. Eastern Standard Time this afternoon, with Mr. Cosby's PR spokesman, Andrew Wyatt. I want you guys to tune in for that as well. And I need you to share this. It is very important that we are getting actual factual information out there to the public and not mainstream media misinformation or negative anti-Cosby propaganda. We need facts, we need the truth, and we need people viewing and sharing. Hello to everyone out there. So I invited the fellas. I'm just waiting on them to come in. I invited Ron Hurd, Gavin Richard, Mr. Dru from Dru Story News. I meant to tell Harvey. I totally forgot to tell Harvey. So we'll see who comes in and who won't. The actual hearing starts at 9:30 a.m. Eastern Standard Time. I am going to attempt to stream the hearing through my channel. Okay, so bear with me. I'm going to attempt to do that. Hopefully nothing happens, but it should play just as if I'm playing a video. Okay, so shout out to everyone this morning. How are you guys doing? Hey, Clay. Hey, Eric. Cool B. Hey, everyone. Hey, everyone. Jamal, Carolina, Don, William, Joni. Hey, everyone. Well, I'm just going to kind of get into it, and whoever decides to join will join. So today we will be witnessing the Pennsylvania Supreme Court. They're going to listen to Mr. Cosby's attorneys. This is the appeal process, and we're going to see where this goes. I believe there's only two portions that Mr. Cosby's attorneys can, in regard to his case, can argue. They can only argue on two main points. So the attorneys, let's see their names. I had them. Shout out to Ms. Kia for sending them to me. Jennifer Bongine. I hope I'm saying her last name correctly. She will be heading this along with Barbara Zemlock and Brian W. Perry. It looks like, so it's going to be three attorneys, but it looks like Jennifer Bongine will be leading this. So we're just going to send them well wishes and hope that this horrible, just atrocious BS will finally be exposed, and the Supreme Court out there in Pennsylvania will do the right thing, because this man, this 83-year-old man, was railroaded to hell. Okay. No one cared to hear the truth besides very few of us. And we've been out here pounding the pavement saying it is wrong what you have done. I don't care what Cosby said. I don't care. That has no bearing on what this system did to him. And to many people, it's not just Cosby. This is everybody. People seem to get it twisted. I have people who come on my channel and they, I like her channel, but I don't care about no Cosby. He said this about this. And you know what? Then don't be here. I don't need you that bad. But my thing is, the truth is the truth is the truth. Wrong is wrong is wrong. And you should not be able to get out here, slander someone via mainstream media, via social media. No facts, just a bunch of BS, lies, and misinformation and propaganda. We're not going to do that. And this is why I have my channel here, because I am so sick and tired of getting on social media and not seeing factual facts. Okay, I'm going to say that, factual facts being represented or told. That is a problem. And you should not want that. You should be shaming your CNNs. You should be shaming your MSNBCs. You should be shaming your local affiliates for not giving you the full factual story, the case. You should be shaming these networks who did not vet these women one iota. You should be shaming them. You should be up in arms, because if they can do this to him, they can do this to anybody. Nobody is safe. And that is what is so baffling about this whole case, is that people just sat back and like, oh, well, it is what it is. I heard it on TV. The memes on social media must be true. And nothing is really being done about this. This is horrifying. All right. Absolutely horrifying. But I am just hoping for the best with this, because it was just disturbing to go to that trial the second time around and to see what happened. And it just seems like everyone is okay with it. I know not everyone, because we're not okay with it, but to see how easily people were manipulated. And I knew something was wrong then, you know? So, okay, who do we have here? We have Dru. Welcome, Dru. How are you, Dru? Good morning. Can I have you turn up your mic? I can't hear you that much.
Okay, hold on 1 second. 1, 2. Is this good?
Perfect.
That's better? That's perfect.
Yes. Now I have with me Dru from Dru Story News. Brother, how are you doing on this cold? It's cold here in Texas. It's cold Tuesday morning.
If it's cold in Texas, then you already know. New York. Yeah.
Right. And it looks like also we have Gavin too. I'm sorry.
Okay.
Yeah, but how are you doing, Dru?
I'm doing good. I can't complain, you know. A lot going on in the world, but you know, I'm staying in my house and just you know, staying away from people and just doing my business, you know.
Right. Absolutely. Thank you for joining me this morning. And I also welcome Mr. Gavin Richard from Gboot 2786.
I want some coffee. What's going on?
Good, man. Good.
Perhaps my special coffee. I need to have some whiskey in it.
I'm telling you, I don't drink coffee, so I have a big hot cocoa. I'm not a coffee drinker, but yeah.
A dry cold. This is cold, so it's I don't know how it is in Texas. I'm sure it's like a dry cold, so
yeah,
not wet like that. Yeah, so
yeah, not wet. It's just cold and dry. Yeah,
yeah. Well, I'm used to it around this time of year, but
yeah. So I just want to get your guys, your thoughts. The three attorneys are going to be representing Mr. Cosby today. Jennifer taking the lead. I've done a little bit of reading on her, and she seems to be pretty good for the most part. And I'm just wishing her the best of luck for today. How do you think this is going to go about? Oh, I'm sorry. Before, I'm going to go ahead and add our brother here, Mr. Ron.
Oh, how you doing? Greetings, everybody. Rise and shine.
Oh, man, how are you?
It's an honor. Great.
Welcome, Ron. This is your first time on Nicole's View, and I know you wanted to be a part of this. Thank you for being a supporter of my channel and wanting to be here today.
You got one of the great things going by New Black Media is you, Nicole. You like the living tradition of Ida B. Wells Barnett, which I visited her birthplace yesterday. So you remind me of her a lot. So
thank you so much. That means a lot.
Ron is literally a historian. Like he can shout out people and numbers, especially Black history, like nothing. So
absolutely.
Thank you. Appreciate it.
Yeah.
Absolutely. So I just wanted to kind of go over what do you guys think is going to come of this? I'll start with Dru. What are your thoughts on the appeal? Do you think there's going to be any success in this for Mr. Cosby. How do you feel about it?
How do I feel? I honestly do not know, because nothing has went. We shouldn't even be here. Nothing has gone as it was supposed to. How they even pulled off the conviction in the retrial is this discussion for months and years in and of itself. This case was not proven beyond a reasonable doubt. When you have, an accuser who just has multiple inconsistencies, evidence of contacting him after the alleged incident, like there was just a preponderance of reasonable doubt. How they got to this point has me dumbfounded. So what's going to happen now? I really don't know. We have a situation where they got this far, which is good, that the Supreme Court is going to look at this case. Now we got to know if they're going to do one of two things. Either they're going to look at this mess and they're going to have to do the right thing and correct this, or they're going to protect the system and just kind of, figure out a way to sweep this under the rug. But this is kind of exciting because I really honestly don't know.
Right. Gavin, you're an attorney, which is why I wanted to, have you on and get your thoughts behind this. What do you think? Can you explain to the audience what's going to basically happen today?
Sure. Well, basically, this is before the Pennsylvania Supreme Court. We already know that Mr. Cosby had lost his appeal in what's called the Court of Appeals. In state courts, it functions almost like the federal courts, where when you get something, you have the district court, then you have the Court of Appeals, then you have the Supreme Court, and district court has the same thing. What you're going to see today, basically, both sides are going to have 15 minutes to make their arguments. One is going to be obviously in favor of Mr. Cosby. The other, which is going to be the state, they're going to make their arguments against granting the appeal. There may be time for a rebuttal by the Bill Cosby's, the petitioners' lawyers, depending on how much time the prosecutors use in those 15 minutes. And you're going to hear likely the Supreme Court asking questions about obviously the prior bad act witnesses. Main thing, Nicole, that people got to remember is that and I read part of that bullshit, excuse my language, I know it's early, but that AP report that they released yesterday about they asked a question about Cosby. What the question was, is a person's past relevant? And the bottom line is this: one of the things they mentioned was that the prosecutor, they had a secret pact. It wasn't a secret pact. He said publicly that there were going to be no charges. That wasn't secret. If you make a public announcement, guess what? It's not a secret. Just like that's like George Bush saying a couple of years ago, saying we're going to go and assassinate Osama bin Laden, but don't tell anybody. Like everybody knows, fool. So you got to be mindful of what these people are doing. It's basically a hit piece. Remember when they granted the appeal that they were going to hear it? Immediately you saw the stories about Lenny Kravitz talking about Bill Cosby and Zoe Kravitz and Lisa Bonet. You saw even another Cosby accuser that came out. So it's all part of this hit job that they're trying to do on Mr. Cosby to keep him in jail. But I do think, it is 50-50, but I think the good thing that may help him is this thing with regards to Time's Up scandal that you had covered on your show Sunday about the monies that was being used for, expensive trips and so forth. That cancel culture thing is getting played out. A lot of people are noticing that. And that's one of the reasons why the Me Too movement went dead. When Biden was running for president and he had his accusations, they stopped talking about it. So I think that he's got it depends on what his attorneys do today, but they really got to hit the nail on all of those subjects hit the nail on the head on all of those subjects today. So hopefully we'll see that.
All right, Brother Ron, I want you to give, because you're the historian here.
If y'all say so. Okay. I'll go ahead.
And just the history of Mr. Cosby and why this is so significant right now.
You know what? Y'all can hear me, right? Y'all can hear me?
Yeah.
All right, cool. Like this is like what Clarence Thomas said back in '91 during his confirmation hearing. This is a high-tech lynching, but it's in 5G now. It's in 5G. And you know, it's an old saying about Pennsylvania, a political saying. It said Pennsylvania, you got Philadelphia, you got Pittsburgh, and you got Alabama in the middle. that's Pennsylvania, right? No, you're dealing in a state that is interesting because right now there's a dispute about the votes, right? The electoral votes. Pennsylvania is always in conflict, right? It's a Democratic state, supposedly, right? Democratic run state. You think about Bill Cosby should not even be at this point. His civil and human liberties were violated. I mean, this guy actually paid almost $5 million to stay out of this situation, right? And nobody never returned his money. So that was a bad investment. So as a black man or as a black person, no matter how many resources you have, you are still a target. You are still an enemy of the state. You look at what Robert Smith, the billionaire who paid out the student loan debts of 300 Morehouse college graduates. They had him under income tax evasion charges. Almost, he made a deal with the IRS with Uncle Sam, the same IRS that broke Joe Louis, the great boxer, heavyweight boxer, who gave $1 million to the government. They still destroyed Joe Louis. And he was doing boxing exhibitions for free. This is what they do to black people in this country. We are, like Malcolm said, anything south of Canada is Mississippi, is the South. You understand what I'm saying? So with Cosby, the reason why he's in this predicament, because Bill Cosby helped a lot of black institutions out. He helped the Spellmans and the Morehouses. He gave back. He tried to create a positive image in the media for black folk. He tried to put himself in a position to control that narrative. You know, the thing about America is that the black folks must be the permanent boogeyman for America. If you even go back to '88 campaign election for Bush, I remember Michael Dukakis. I thought he was going to win. I was in the 3rd grade. I thought Michael Dukakis was going to win when he put that silly helmet on. But what happened was that Willie Horton commercial, right? When he was governor of Massachusetts and he had that furlough program, and Willie Horton took advantage of it. And so Lee Atwater, who is the brain for the Bush and Reagan campaigns, he the guy who really put the Southern strategy on steroids. He okayed that commercial. Also, he's the mentor of Karl Rove, who was Bush's junior brain, his Spingazi. You know, so the thing about it is, a black person must always be the boogeyman for America to feel good about itself. In particular, a strong hetero alpha black male like Dr. Bill Cosby, who's from Philadelphia, who also did that thing to move. 35 years ago, you had a black mayor of Philadelphia, John Wilson Good. I call him John Wilson No Good. You know, he still can't live that down. I don't care how many literacy programs or how much he give back to the community. Community will always hold him accountable for what he allowed to happen to John Africa and his family back in May of '85, where they bombed an American city the second time since Tulsa, Black Wall Street, which will be the centennial next year. And Bill Cosby was involved in creating a documentary about Black Wall Street for HBO, I believe, back in the day. 20-something years ago, Bill Cosby was involved in trying to tell our stories. So we got truth tellers out under attack. And Bill Cosby, whatever he did, we attack. We forgive Joe Biden for the crime bill, but we can never forgive Bill Cosby for the pound cake speech, which is ridiculous. And Bill Cosby was one of the first entertainers to boycott when Cincinnati was losing its mind. I remember when I was in college in St. Louis, when all these black folks, especially black men, were getting killed in Cincinnati by the police back in the 2000s. Bill Cosby was the first national entertainer, from my knowledge, to boycott Cincinnati for how black folks were getting treated by the police down there or up there, whatever. Everything's south, up south, down south, up Mississippi, down Mississippi. Everything's the South in America as it relates to black people. But Bill Cosby, I don't think he's gonna get a fair shake because they still got Mumia Abu-Jamal in prison. People talking about Meek Mill. What about Mumia Abu-Jamal? A Black Panther who was framed. He shouldn't even be in prison. He's dying. They H. Rap Brown. They punishing H. Rap Brown for what he did and said in the 60s. What's a guy, H. Rap Brown, the Black Panther, the last chairman of SNCC. They don't never talk about the real. See, they highlight John Lewis, who was the chairman of SNCC. But the first chairman of SNCC was Marion Barry, one of our greatest political geniuses. But we want to label him as a crackhead because of the media. But the things he done for
I
black
talked about
folk,
that last night on my show.
Yeah, but Obama ain't did nothing for us to pay lip service. But this guy actually did the stuff that we think Obama should have done as mayor of D.C. when they got home rule. That's the reason why they took away home rule, because of Marion Barry. That's the reason why the government spent almost $50 million to take him down, because the people love him because he was a servant of the people. And Cosby, no matter how flawed he was and is a servant of the people in terms of what he was trying to do for the overall image and support of black people in our institutions. It's a travesty. He won't get any justice because they're not qualified to give justice because the devil is only qualified to give more hell. You beg the devil for hell, you get this. This is what we get. And black folks, we need to have a backbone and really come together. And that's the problem.
Absolutely. Whew, that was hot. That was hot.
I'm up this morning. I took my vitamins. I'm good. I'm very excited about this show, Sister Nicole. And Dru, I love your stuff too. And Gavin, I mean, it's an honor to be among y'all. Great company.
Thank you, man.
Absolutely.
All right, brother.
Let's see. So we have like less than 30 minutes until this whole thing starts. I'm always double checking to see when it starts. And when it does start, I'll just ask you guys just to mute your mics. And then I'll just have it full screen for everybody to see. And you can stay right here on NICOLE'S view and watch it with us. And then once it's over, we can just come back, unmute, and then we'll just talk about, what went down. And Gavin, you can break down the legal lingo of what you think happened and whatnot. So Dru, I'm going to go back to you. You've done so many videos, commentaries about this. When was the first time that you knew that this was like, okay, this is totally not right?
It's a good question. I was a blogger before YouTube, and I took an interest in media deception. And then once you catch it, there's so many different cases I covered where you catch government lies, where you catch media lies, and then you sort of get hip to certain formulas and patterns. And there's certain things like about journalistic ethics that when it's deliberately like they're lax, something's going on. And what I saw was not that I initially was doubting the truth of what was being told. It was just a rush to push it on television. And there's just a gut feeling. And I still didn't post anything, didn't write anything. I'm just watching this like, this is a little weird because there's just this speed with which they did this. And you can break this down to a science. Someone behind the curtains is thinking. You had Hannibal Buress, basically completely unknown guy. I don't know if he's funny. Don't know anything about him. He's completely unknown. Goes viral with this bit about Cosby that was not funny. It's like something you don't really joke about, even if it was true. Cosby's a rapist. He's a rapist. He's a rapist. And I'm like, that bit was like a weird to me. And then he goes viral. Right after that, on the, when it was at the peak of going viral, they dropped Barbara Bauman. And then right when you were just processing that, like, whoa, what's going on? Boom, Beverly Johnson. And then right after that, Janice Dickinson. At that time, people didn't even care about Janice Dickinson being a pathological liar. It was just the public theatrics of and the spectacle of all those women. And then it quickly became, the Me Too dog pile where you're not you're not using any critical thought, you're not using logic and reason. The logic of the day quickly just became, well, look at all those women. They all can't be lying, guilty. So I knew that was wrong. Something was wrong with that. And when you see Janice Dickinson in the lineup, and you just look into these people, you look into Beverly Johnson, people didn't even know that while these people were coming out, there was people in their hometown saying, oh, I know her. She's a drug addict. She's a liar. The media was hiding these things that were, going against the mainstream narrative, including Beverly Johnson, one of the most famous. People didn't even know that her manager at the time, Don Gibble, said she was lying. And the reason why he said she was lying, he didn't have a dog in this race. He's just like, listen, I remember that Cosby meeting. She said that Mrs. Camille Cosby was there as well. And she spoke highly of the meeting. It was a great meeting. And she's told that story over and over again for years. There was no, weird thing. Then all of a sudden, the Vanity Fair piece, there's this whole new story. And he's like, what? So every single one of these accusers, if you can do a video on each one individually as to how they lied. So, the first one, Barbara Bauman, when she told her story, I'm like, wow, people are not even getting that this is not a case of rape. She told on herself. She basically told on herself. And then she started to describe multiple sexual experiences, and
We called
the
him as
liars
her golden
lie.
ticket, if I'm not mistaken.
Right. She said Bill Cosby was my pot of gold
Yes.
that I needed to take care of. Basically, you knew you were a kept woman, you were a mistress. So is it rape?
He take
Is
my
it
money.
yeah,
When
you know,
Yeah,
So,
that-
yeah,
wow.
he's a trifling.
The media, I mean, the people are not even hearing that they're lying to you. They're telling you that they're lying.
right.
And so that's when I said, you know what, let me piece this together, because the media is very good at what it does.
Mhm.
And you know what, for the logical people who really want to know what's going on, like, let me put something together that they can see step by step and say, oh, okay, this is what's going on.
Right. Yeah. And for me, especially when I saw Beverly Johnson come out, because you remember initially it was just like white women coming out. And they
Right.
were like, wait a minute. For that one split second, there were black people saying, wait a minute. And that's when we should have said, stopped at wait a minute.
Right.
But we saw Beverly Johnson come out, like you said, in this Vanity Fair, and she's all made up and she's looking all stoic. It just seemed fake. It seemed scripted.
Right.
And that's what I knew. I was like, okay, this is what they're doing now.
Right.
You know, and Gavin, what was it for you that you were just like, you know what, this is BS. This is just like, what was that moment for you?
Nicole, would you do me a favor? I'll answer the question, but could you send me the link to the actual live stream that is going to be happening? I can't find it for some reason for the appeal.
Okay, I can send it to you
From
via
the courts. Yeah, the courts link.
Can I send it to
Yeah,
you?
that's fine.
Okay.
All right. What now? Could you repeat your question for me?
Well, I just wanted to know what was the moment that you knew that this was BS for you?
Well, when it started to just snowball,
right?
Because I just saw all the accusers come out. You know, Dru mentioned Barbara Bauman. I remember. I think she was being interviewed by Don Lemon, if I'm not mistaken. I didn't pay any attention to that. But then when I started to see, well, Beverly Johnson's coming out. Now, Beverly Johnson was one of the hot. You know, that's Miss Trinidad from Martin. You know, she comes out, and I saw Michael Eric Dyson throwing support behind her, but Dyson has always been an opponent of Bill Cosby. You know, he was clearly biased in even how he handled this situation. If you look at some of the comments he made, saying that Bill Cosby has raped the black community, even Cosby's spokesperson condemned him for making those remarks. At his, I mean, it was his attorney at that time. The other, then when you saw Janice Dickerson and her comments, when they started to take her stuff seriously, and Janice Dickerson is a known liar, as Dru said, she's a known crackhead, for goodness sake. She got Sylvester Stallone. I mean, literally, she looks like an extra out of Breaking Bad. You know, she did that. That got his stand-up special, Cosby 78, that he shot in San Francisco. That was supposed to was shot on his birthday. In San Francisco, Robert Townsend was the director of that special. They pulled that special. They also took away his show. So I just saw, and then you saw all of these other accusers one by one, and then Gloria Allred gets in the mix, and we know what she's about. She's an ambulance chaser. You know, I just saw all of that, and that's what really just turned me off about it. You know, and as a black man in America, we all know that any black man that would have done something as far back as 1960, when interracial marriages were against the law, for goodness sakes. A lot of people have this mistaken belief that California isn't racist because it's liberal and it, you know, that free love and hippie stuff was out there. But this is still the United States. The United States is one of the viewers stated in the comment box is basically one big South. This has always been a traditionally racist country towards black men. And I certainly I would not expect a white woman who would be sexually assaulted by one of the most popular premier entertainers of that time would be afraid to come out especially when he's under FBI surveillance. Keep in mind something: Bill Cosby was on Richard Nixon's hit list, enemies list. He was one of hundreds that was on there, including Dick Gregory. Dick Gregory was right on that list as well. Ron and I knew Dick Gregory personally. Jane Fonda, a couple of other people were on there, and of course Jane Fonda, she talked smack about Cosby. But all of this stuff, basically, what you're seeing is this is a regret. This is basically sex with remorse. People that are coming out trying to make money off of a situation that happened 40, 50 years ago, where they thought they were going to advance their careers, and it didn't work out the way that they had intended. And sadly, this is the consequence of what we're seeing.
Yeah. Brother Ron, what did it for you that you felt like, okay, this don't sound right. This is not okay.
Well, it never sounded right to me. And you got to trust your instincts. We've been taught not to trust ourselves when it comes to information and intuition. And we are our own worst enemies when it comes to try to find out truth a lot of times, because we just accept anything and everything without asking the right type of questions. Like with Cosby, people got to go back to 2014, right? The Hannibal Buress stuff came out the end, right? Mm-hmm. What happened early 2014, Bill Cosby and his wife, Dr. Camille Cosby, own a lot of land on the Northeast, Massachusetts, Pennsylvania. You had an energy giant called Kinder Morgan, one of the biggest energy giants in the country, trying to build pipelines through their property. So they came out with the environmentalists and conservationists to protest Kinder Morgan trying to impose or get into their property to build this pipeline. Like what Baba Dick Gregory would say, Cosby property got more oil than Kuwait under it. So Camille actually wrote an op-ed, I believe, back in March of 2014, coming out against Kinder Morgan, supporting the environmentalists on this. That's March 2014. You can find this online still. By the end of 2014, that's why all these accusations though come out against Dr. Bill Cosby. So all this stuff is tied in. Because you look at our history as a people, we all have stories in our family trees about ancestors. I call them ancestors, owning lots of land and getting run off their land. Think about 1898 Wilmington race insurrection, the only officially recognized coup d'etat in American history after the Civil War. We had black folks in Wilmington, North Carolina. It was a real chocolate city, the largest city in North Carolina, owning all this land and all these businesses. But the out-of-power Democrats led the white supremacy campaign of 1898. They call it white supremacy back then, to overthrow the dutifully elected government of Wilmington and ran all them black folks out of town. They left all those businesses and lands, where the state of North Carolina did a 5-year study back in the early 2000s to understand the effects of all these black folks losing their land. That's generational wealth that's lost to us. So we have a lot of Black Wall Streets in our ancestral memory, and it's generational trauma that it produces. So Cosby is just the latest line. Like I said, Dr. Bill Cosby did a documentary with the Tulsa Black Wall Street survivors that came out on HBO about maybe 20 years ago. And, Dr. And Johnny Cochran was involved in trying to get reparations for the descendants and survivors of Tulsa, Oklahoma. What happened to Johnny Cochran? He was replaced by Benjamin Crump.
Yeah.
Think about it. They killed Fred Hampton Sr. in Chicago. His anniversary of his death is coming up on December 4th, the same day that Jay-Z was born. December 4th, 1969, 4 o'clock in the morning. They replaced Fred Hampton with Jesse Jackson. The Rainbow Coalition was a phrase that Fred Hampton Sr. used to understand how he organized the gangs of Chicago. The white gangs, the black gangs, Latino gangs. He organized my, he called this my Rainbow Coalition. That's what Jesse Jackson got their term from Fred Hampton Sr. So they killed Fred at 21. They were spying on Fred when he was 14 or 15 years old. The government, his mama used to babysit Emmett Till. His mama was Emmett Till's babysitter. Wow. Think about all that trauma and tragedy. That's just us. That's a microcosm, but it's all of us. You understand? So we always under attack.
Yeah.
When people talk about black people, talking about we got high blood pressure and diabetes and all this BS. If you are always in constant fight or flight mode, we're never at rest as a people. We could drive down the street. I don't care how many PhDs or how many millions of dollars in the bank you got. You get scared when the police get behind you. You don't know what the hell they're gonna do. I don't care how world renowned. Think about Skip Gates. I don't care how recognized you are. You still just a nigga. No matter what you do. So with that, we got to understand that we are constantly in fights or flight mode as Black people. So that trauma, with generational trauma and also personal trauma compounded, you create what we got with Black folks right now.
Yeah.
We're trying to fight for justice in a system that don't even recognize our full humanity. You know, people talking about what the 3/5 compromise was about politics. Well, they treat us like 3/5. Think about Dred Scott back in 1857. He's buried outside of Ferguson, Missouri. I don't call it Missouri. I don't call it Missouri. It's misery. It's a state of misery. And the Supreme Court Chief Justice Roger Taney, in his opinion, said, or his decision, said that you nor your descendants have any rights that the white man by law is bound to respect. And in 2020, why should they respect us? We don't respect ourselves enough to get the hell out this damn system. And I'm gonna tell y'all this too, because this is a class in session, right? I'm gonna shut up about this, Nicole. I know it's your show.
Oh, sorry.
All white people are racist. That's not for debate. This is a racist system. Not all white people are white supremacists. Not all racists believe they're superior. They just want the advantages they could get from exploiting and keeping you in a certain permanent class position. You got Black people that's white supremacists. That's a religion. Your belief in something is superior. Racism is a system that if we got in power, we could be racist if we wanted to. But we're not in power in the system. So I don't want to, or Joe Biden, Trump, they're all racist, hell. That ain't the point. The point is, are they white supremacists? And Joe Biden has proven over 47 years of a political career, he is a white supremacist. He is a neo-Dixiecrat.
Yep.
So you got a neo-Dixiecrat system. Cuomo is worse than Trump. He's like Mussolini for real up in New York. He's a fascist. And you up there, Drew. You know what I'm talking about.
Yeah,
I'm going to shut up now. I don't know if I asked your question, Nicole, but that pipeline thing, people need to go back to that Kinder Morgan thing when his wife and him came out against it. The same year he got accused, all these accusations started coming up. That's why I knew it was BS.
Right.
I'm sorry. I talked too long. I'm sorry.
Kia and I did something on that, the Kinder Morgan thing. And like a lot of people don't know, connected to that, a lot of people are just unaware of who and what is lurking behind the shadows. And there's a guy, I think his name is Rick Berman, who is connected to companies like Kinder Morgan, if not Kinder Morgan, and a company that represents them. And he said in an interview, bold, several years ago, that he can get rid of celebrities. He can get rid of activists. If you get in the way of big, powerful interests, big oil, big entities, they can do what they did to Bill Cosby to you.
Yes.
And I think people are walking around unaware of the mind of the psychopath and the sociopath and these sociopathic entities, that they have no problem lying. And my problem was just the willingness to just believe whatever they're told on television. That really disappointed me. Like, even when you provide them with information and facts, and just this obstinance and just subservience to news, that if you did a little bit of digging, you would uncover, like, yo, this is very suspect. And that I found very disappointing.
Let me say this, if I could. Media is about sensationalism. It is not about news. Even when Michael, because Nicole, I know you love Michael a lot. Dick Gregory was close with Michael Jackson. When Michael worked on The Wiz, Michael had a collapsed lung, and no one knew how to take care of it. Dick Gregory actually fixed up some medicine for him and healed him within hours. And Michael never forgot that. He was at Michael's trial. He would come in when Joe wasn't there. You would see Dick there. But reason why I bring Dick up, remember what Ron mentioned about the oil, that pipeline on Bill's property in Massachusetts. Dick told me and told everybody that under the ground in Neverland, there was more oil than Kuwait. You know, he used to say things like that. What a lot of people fail to realize, because people are not interested in facts. One of the accusers, and I'm actually going on this in my book, Sean Brown, Autumn Jackson's mother. Now, you remember back in 1997, Bill Cosby, and Tariq talked about this too. Bill Cosby was accused of fathering that girl back in the 90s. But then we found out that she got arrested because she sent that fax demanding money, I think millions of dollars, in order for her to keep quiet. And that same week was when Bill Cosby's son, Enos Cosby, was murdered. I think it was not even within 3 or 4 days after Enos's murder. And what a lot of people don't know, Autumn Jackson went to jail, but also several other people went to jail with her. And they both, I believe, were Ukrainian Russian. The man that killed Bill Cosby's son, he's the confessed killer, is from Ukraine Russian. He's a Ukraine Russian Jewish immigrant. So a lot of people don't know those details, but she's actually more important in this case than even Andrea Constant, because he's the only one he acknowledged that he had an affair with. But also, she also stated that the child wasn't his. Somebody else was claiming that. But people don't do research. People don't go back. And then, of course, she comes back 18 years later when this stuff is going on. Remember, she came out. She was one of the accusers, I believe, when Cosby was being sued by Constant. They just allow this shit to continue over and over again, and they don't vet. And it's part of a much larger agenda, like what you guys saying. This is basically extortion 101. This is what you do. And when you have the media in place, when you have fools and puppets like Don Lemonade and who's the other one? Let's name them. Just a bunch of them. I can't even name.
Roland Martin, your favorite target. Roland Martin.
Yeah. Welcome to no. Roland. I don't think Roland actually was. He was in on a hit piece like this, but Tom Joyner even dissed Bill Cosby.
D.L. Hughley,
D.L. Hughley.
That's personal, right there. That's real personal.
Habitually, habitually. Yeah, D.L. Hughley. You had Wendy Williams, Wendell Williams, I call her.
Mark. Yep.
Mark Lamont Hill, Michael Eric Dyson. All these sellouts, basically, including some. They all make these comments about this man. And that was more. Well, the thing with DL, that was more personal because
he's a repeat offender.
Yeah. No,
he came out on Michael, came out on R. Kelly.
But that was something personal because, like, Faison Love even talked about this on Vlad, where he's talking about his style of comedy. Same thing with Earthquake. Earthquake came at Bill Cosby. He did stuff talking about how Cosby was guilty. That was because Cosby was critical of Def Comedy Jam and their style of comedy and so forth. But they act like they never had an elder tell them to watch their language.
Yeah.
Like, come on, y'all have lived with it for a long time. You're in your 50s. And yeah, DL, I know he's spoken out against Michael and he's spoken out against OJ. A lot of people, like he just came, and when he came at Michael, and then what was funny is that he interviewed Tito on his television show, and I don't know if Tito knew about the stuff he had said about Mike, but yeah, I was disappointed with brother DL lately, but yeah, man, but all of these guys, but Tom Joyner was the one that really I was more pissed off at because he and Cosby are both frat brothers, Omega Psi Phi. And every time Tom Joyner did a Sky show, he used to have something called the Sky Show where he would be in town in a different city. When he came to Philadelphia, Bill Cosby was there helping him out. He raised money for historically Black colleges and universities. And he wrote a hit piece saying, well, Bill Cosby should just go ahead and confess without even waiting on the evidence. You don't do stuff like that. Journalism is there's something called journalistic integrity. You do it, and integrity means, I'm not interested in whether you like a person or not. I'm about working in the public, and I'm going to relate the facts to them, all bias aside. That's what that is about. And unfortunately, we don't have that in media.
Yeah. Or in black media. I think more than media, I think black media was put on Front Street with this because, like, I did it in my room. And these major publications couldn't point out simple common sense things. There was no defense. There was no objectivity. And black media exposed itself.
Right.
Yeah.
Exception of
Essence, Ebony.
Did you see?
Right, but you see those magazines are folding right now, especially Essence.
Oh yeah.
They don't have any value anymore. They're not what they were anymore. Ebony is folding. They have money issues. You know, all of that is going on. And you know what was interesting too? I saw I didn't see the clip, but I saw the headline. DL says that Bill Cosby should be released from jail.
Oh,
He
now?
was on Vlad. He was on Vlad. Yeah, he said they should just let him out.
He's probably seen the tide change.
Right.
Because he was
yeah.
Initially, he's always in the front. Anytime something happens, R. Kelly, he's on TV dragging him.
Yeah.
So you know he's a habitual. He's a repeat.
Habitual line stepper.
Habitual
like
line.
Charlie Murphy would say.
Right. For me, you know, and you guys know I've been so deep in this, and for me, how I knew when it all came full circle.
I'm actually Facebook friends with him too.
Oh wow,
from a long time ago.
Should tag him.
It's just crazy because for me, as I got into this and I just really started researching this and connecting the dots, and then seeing how we were talking about Janice Dickinson. If you go back in 2013, Janice Dickinson filed for what? Bankruptcy.
Bankruptcy, yeah.
And then remember the next year, 14, here comes all these allegations. Yeah. And then here she comes. And she was one of the 10 or 12 women that settled with Cosby's insurer, AIG.
Yeah.
Okay. And remember how happy she was.
Yeah.
With Lisa Bloom at that press conference. I said, see, this is all coming full circle. And if you're paying attention, you will see what this is. This was
and it's a really satanic situation because one of the at least half of the people that won, half of them you can prove right now that they lied. Yes. One of them was Janice Dickinson, and she did lie, and she admitted that she made up the story for her book. Another one was Chloe Goins. And
well, she got caught lying. The prosecutor
got caught lying.
She got caught because Cosby had records to show he wasn't there. So when they give a date,
and so her case was not successful. And a year before she won the settlement, she was arrested for smuggling heroin, and you know, mysteriously she was let go. I mean, this is not a small charge. Like she was caught smuggling heroin into San Diego jail, and she was arrested.
Contraband.
She was arrested in the jail parking lot, and somehow she walked out free. And you know, almost a year later, she wins the settlement with AIG.
Yep, another one.
This thing is big, and it's very, very satanic. And you know, people are keeping their eyes on Bill Cosby as the bad guy, but they're not seeing all these scoundrels, the criminals, the demonic entities that are winning settlements and lying to you and getting, you know, coddled by the Me Too movement. This whole thing is very satanic.
It is. Absolutely.
Nicole, Ricardo Gordon asked the question, is the appeal today? Yes, Ricardo, it is.
It is going to be in 2 minutes. I'm just clicking back to see when they go live. Like I said, I'm just going to stream it right on my channel. We're going to mute the mics, and I'm just going to have it right here so you guys can just stay right here on Nicole's View and watch it. I'm just hoping for the best. I am hoping that they listen to this. I don't know how to feel about it. I don't know if he'll win or not, but I'm just going to stay positive, send positive vibes to Mr. Cosby's legal team, because this is all horrific on every level imaginable. I wouldn't wish this on my worst enemy. Like Brother Ron said, yes, Cosby may be flawed, but this right here is absolutely not okay. We're not just gonna sit up here, throw an 83-year-old blind man in jail, no questions asked, not investigate these people, and everything is good, and we have a corrupt DA. And you mentioned, Brother Ron, about the Willie Horton ad. This same DA, Democratic DA, Kevin Steele, ran the same type of ad about Bill Cosby. Yeah. We're not going to do this. We're not going to do this. This is not okay. I don't care how you feel. Right is right and wrong is wrong. Period.
Yeah.
Period.
Right. But it is going to be very interesting, because if you just take your emotion out of this, you know, it doesn't matter what you believe legally, and I'm sure you'll agree, Gavin, this needs to be corrected. This should not have happened. So it's very interesting to see what they're going to do when they pull all this out.
If it
And
is not, go ahead. I'm sorry. Finish. I'm gonna make
when
a statement.
pull all this out, like regardless of emotion and opinion, this was a kangaroo court.
Yeah.
There should not have been a conviction.
Mhm.
And any person with a legal education can look at this for a few minutes and realize that very quick. So it's very interesting to see what they're going to do when we pull all this out.
I wouldn't call it a kangaroo court because that would be offensive to kangaroos all across Australia. This was a high this was like Brother Ron said. This was a high tech lynching, starting in social media with the memes. That DA and prosecutor need to be, as far as I'm concerned, as far as I'm concerned, Judge O'Neill needs to be admonished from the bench. He needs to be removed.
Yeah.
I think that the district attorney needs to be disbarred. I think, although I know that's not likely going to happen, but all of that needs to be forward. If indeed this case is not corrected, because it may end up in federal court.
All right,
and
guys.
They allowed us to go to Mr. Cosby.
It's like they're starting. Okay, let's go ahead and mute the mics. Please mute your mic. Please mute your mic.
In light of prevailing public health. Let our technical people and counsel work with those who will argue at a time, and we do the very best we can to make it work. But you never know what might occur with technology. So we've usually been able to work around those. So if they occur, we'll do the best we can as we try to move forward with today's list. I conclude by reminding all of you, though, in any event, that we do have the benefit of your briefs. We're very familiar with the case. So you needn't worry if you miss a point or if there's a technical issue, because there's nothing that you would argue that would be encompassed in your written presentations. With that, we'll call the first case.
First matter is the Commonwealth of Pennsylvania versus William Henry Cosby Jr. Representing Mr. Cosby is Miss Jennifer Bonjean. Representing the Commonwealth is Miss Adrienne Jappy and Mr. Robert Fallon.
Good morning. In this case, the felon was convicted of aggravated indecent assault stemming from an incident that occurred in 2004. Prior to trial, the felon moved to dismiss the charges, claiming that the prosecution had granted him immunity for criminal liability. To testify regarding their accusations of sexual assault against the appellant for purposes of establishing appellant's common scheme or plan. The issues before the court are whether, one, the testimony of the five witnesses regarding their respective accusations was admissible evidence under Rule 404B, and secondly, whether there was a binding agreement between appellant and the Montgomery County District Attorney that would result in immunity from criminal prosecution. With that, we'll proceed with the appellant.
Good morning, and may it please the court. In our system of justice, a defendant must be tried for what he did and not who he is. And yet the prosecution has made no secret of the fact that it intended to indict Mr. Cosby's entire life. After failing to secure a conviction after Mr. Cosby's first trial, the prosecution shifted strategy, laying waste to the presumption of innocence and telling the jury that Mr. Cosby's claim of defense could not be believed because, quote, he had done this so many times before. The prosecution forced Mr. Cosby to defend not only the charged offense, but 5 mini trials and vague accusations from countless Jane Does dating back to the 1970s. And while the public and the media were free to judge Mr. Cosby's guilt based on those factors, his criminal jury was not. And perhaps a limiting instruction served its purpose at Mr. Cosby's first trial. But there can be no confidence that it did its job at the second, where the jury was bombarded with prior bad act evidence. Indeed, half of the prosecution witnesses testified in connection with uncharged 404B allegations. Some of the allegations, the most damning ones, came from a deposition that should not have been admitted in the first instance on account of an agreement with the Montgomery County District Attorney not to prosecute Mr. Cosby, a promise on which he relied to his grave detriment.
They both from the Montgomery County did.
As argued in our briefs, none of the prior bad act evidence served a legitimate non-propensity purpose. But that aside, consensus surely must be reached that Mr. Cosby suffered unquantifiable prejudice where the PBA evidence or the prior bad act evidence overwhelmed his second trial, converting it from a trial on a single offense to a trial of his character. And with that, I would entertain any questions from the court.
Counsel, this is Counsel Justice Doherty speaking. Let me just zero in on the civil deposition. Even taking into consideration and finding is true that he, Mr. Cosby, your client, did not believe that he was to be prosecuted for the events involving Ms. Constantine. Tell me, when confronted with a question plausibly implicating criminal conduct in any deposition, an individual has an affirmative duty to invoke their Fifth Amendment regarding other issues or potential other criminal conduct. Why was that not done by counsel for Mr. Cosby or Mr. Cosby himself?
I think that speaks to the agreement, frankly, that the agreement not to prosecute was linked to the willingness to give a civil deposition, which we know this in part from looking at the press release, which demonstrated that not only did the district attorney at the time, Bruce Castor, decline to prosecute, but he mentions in the press release that there was going to be ongoing civil litigation. So, and you also can look at Mr. Schmidt's testimony, who's testified that it was our understanding, it was our belief that the promise not to prosecute would be honored so long as Mr. Cosby agreed to sit for this deposition and give testimony and not invoke his Fifth Amendment right, which he did, again, to his detriment. And in hindsight, of course, we would have preferred to have seen a written agreement or something on the record that would have reflected that this was the arrangement that had been made. But I think the fact that Mr. Cosby actually sat, answered questions for 4 days, and I think it speaks to the court's point that this is evidence in and of itself that he relied on this representation. No one would sit for a deposition and not invoke their Fifth Amendment right, guilty or innocent, if there was the possibility of criminal prosecution looming over your head. So the fact that he did leads to the only reasonable inference that he believed that in order to not be prosecuted, this was part of the agreement that he complied with. And as a result, to the extent that the prosecution wanted to use the deposition testimony, once they decided to prosecute him, that deposition testimony should have been off the table at a minimum.
Counsel Justice Baer, at the first trial, and I don't think it's in our record, but it is properly before us, was there any prior bad act testimony?
There was one prior bad act witness who testified at the first trial, correct.
And of course, you didn't take an appeal because that was not a conviction.
That's right, Your Honor.
I understand your argument. I tend to agree that this evidence was extraordinarily prejudicial to your client. But there's a trial court discretion component here. In your view, if the trial court had allowed one again, would that have been an abuse of discretion? Or if the trial court allowed two? And where do we as an appellate court draw a line between abuse of discretion and a discretionary call, which perhaps we would have not made, but which we're not powerful, we don't have the power to overrule?
Yes, understood, Your Honor. Our position is the trial court abused its discretion for two reasons. One, because not even one prior bad act witness served a non-propensity purpose, but also because the admission of 5 prior bad act witnesses was unduly prejudicial to the point that no limiting instruction could have cured it, and that these 5 discrete allegations from 15 to 22 years ago had such minimal probative value as compared to the danger of unfair prejudice that it seems clear that the court did not exercise discretion in allowing 5. So it's twofold. Our position is that there was no theory of admissibility that was for a non-propensity purpose. But even if this court were to disagree with that, at the end of the day, 5 witnesses, plus all of this vague testimony about Quaaludes and Jane Does that were just exploited to the hilt during the closing arguments, that frankly were just contorted from the deposition testimony in the first place, put Mr. Cosby in a position where he had no shot. The presumption of innocence just didn't exist for him at that point. And so I think the court abused its discretion in both of those ways.
Thank you.
Counsel, this is Justice Donahue.
Good morning.
Good morning. Since you're not going to have time for a rebuttal,
yes,
I would like you to, for me, spend a little bit of time talking about why the evidence that was offered through these prior bad act witnesses did not go to establish a common plan or scheme or a signature crime, which is what I understand their purported use was.
Yes, Your Honor. So at the outset, I would say the common plan is an inapt theory of admissibility here for 2 reasons. One, because the prior bad act evidence was not part of a single overarching plan, which I think the prosecution concedes. It also was inapt because identity was not a disputed fact in this case. And the overwhelming authority from this Commonwealth and across the country is that signature-like prior bad acts, also known as modus operandi evidence, is relevant to prove identity. In fact, the test in this Commonwealth is that it must be so nearly identical to be the handiwork of the same perpetrator. But when identity is not in dispute, the evidence simply registers with the jury as propensity evidence. To put it very simply, where identity is a dispute, a modus operandi may be perfectly proper. Where identity is not in dispute, it just amounts to propensity evidence. And make no mistake about it, that is what the prosecution is asking this court to do, is sanction propensity evidence. And simply because the prosecution can shoehorn prior bad act evidence into some exception, it does not make it admissible, since it may not bear on a matter at issue in the case. But with that said, if any members of the court disagree with that analysis, and that may be the case, even if this court believes that the signature crime approach is the appropriate approach to this case and a proper theory of admissibility, the prosecution still does not prevail here because the prior bad acts were general in nature insofar as they involved sexual misconduct of some type and the use of an intoxicant. They were not nearly identical as to the charged offense, at least any more nearly identical than they would be to, frankly, almost the majority of acquaintance assaults or date rape situations, where we know that intoxicants almost invariably play a role in those types of assaults. But if you want to get more granular about it, in this case, we have prior allegations, again, 15, 22 years old prior allegations that involve a number of distinctions from the charged offense. I think one of the most astounding ones is the nature of the relationship. You cannot compare the relationship that Mr. Cosby allegedly had with these 5 other women that he did with the complainant. This was an 18-month relationship. This was a relationship that, at least by her own testimony, was built on friendship. They exchanged gifts. They spoke regularly. This notion that he was mentoring her, well, I mean, anybody who comes in contact with Bill Cosby is going to sort of, given who he is, could perceive that he would be a person who's wise and would be able to give you advice. But this is not the scenario where he sought her out or she sought him out for some to advance her acting career or a modeling career. This was a chance encounter. He brought her into his inner circle as a friend, introduced her to people he knew. He traveled to places with her, New York, Connecticut. So the nature of this relationship was very different. In the 5 prior bad act cases, one woman had not even been invited to Mr. Cosby's home. She just came with a friend, and she was not an actress, and she didn't. This was just a woman that showed up to come socialize with Mr. Cosby with their friend. The other women had met him once or twice. So again, the nature of the relationship, I think, is a marked difference between the prior bad acts. We also have very different sexual type of contact. One of the women, Ms. Lublin, testified that she doesn't recall any sexual contact other than some bizarre behavior where he allegedly stroked her hair. And some women describe, intercourse where other women describe that there was something that didn't involve penetration. So the sexual acts themselves were very different. The nature of the intoxicant was different. In some cases, like Ms. Baker-Kinney, she said, I took the Quaalude. He offered a Quaalude to me, I took it. There's no evidence whatsoever that anybody else was given a Quaalude. Even among the other 4 prior bad act witnesses is in the charged offense. For as much as Quaaludes played a role in this case, from the prosecution's perspective, they will concede. They have no evidence that Mr. Cosby gave Ms. Constant a Quaalude or anybody else, frankly. The only person who speaks about a Quaalude is Ms. Baker-Kinney, who said, he offered me one and I took one. So, yes.
This is Justice Todd.
Good morning.
Good morning. Let's assume we accept your argument on prior bad acts, that it was error to introduce it. Could you address the harmless error question? Could this possibly have been harmless error?
It could not have been harmless error, and I think we need only look at the first trial to get our answer to that. It is clear that the prosecution wanted and needed propensity evidence, but they had no right to it. You don't get to make up for weaknesses in your case by bombarding each jury with rank propensity evidence. That's not fair. And frankly, the prosecution's case, the evidence was ample. They didn't need this evidence. They had the complainant's testimony. They had corroboration. They even had an expert who was able to rehabilitate any cross-examination. And with that, the first jury still could not reach a unanimous verdict. And as a result, I don't think that this is a case where there was overwhelming evidence of guilt. And I think we have the benefit of this first trial to tell us that. And yet, the prejudice, again, was extraordinary in this case, and no curative instruction could have solved it. I think the Third Circuit said it best when it commented that when an evidence of this magnitude is presented to a jury, it is most difficult, if not impossible, to assume the continued integrity of the presumption of innocence. And to put it, yes.
Now, this is Justice Doherty again.
Yes.
Let me return to the civil deposition because I struggle. It appears that your argument is based upon promissory estoppel, correct?
Correct.
So again, when we're looking at the parties with regard to promissory estoppel and each individual factor, the concern that I have is here, as you indicated in your opening, they're trying to dissect or look at his entire life. And that being that, I assume you're implying that he's a celebrity, therefore this is even a harsher look at him. With that in mind, my concern is how are we to accept one of the second prongs of promissory estoppel is justifiable reliance on the inducement when we have to look at this individual. We're dealing with an individual who's knowledgeable of the legal system. He's in entertainment. It's not as if this is his first advancement or use of lawyers. So how is it when you take into consideration the inducement, AKA the Castor press release for which he signed indicating that Cosby would not be prosecuted for the instant matter of investigation. How is it that we're to find justifiable reliance of an individual who's intellectually, at least legally superior than the average person, based upon his history, as you brought forth in your argument, to really rationalize that he justifiably relied upon refusing, or the DA's refusal to prosecute, yet provided additional elements of other individuals, not the focus of the initial criminal investigation, and yet affirmatively refused to invoke a Fifth Amendment. I'm struggling with your argument.
And I understand that, Justice. I think I would disagree with one premise, which is that the assumption that, and with all due respect to Mr. Cosby, that he is particularly savvy about the law, or that he has an understanding of these things. I think high-profile people often rely almost to their detriment on legal advice. They have a lot of legal issues, and they defer many times to their attorneys, who tell them, this is the deal. You know, this is part of the agreement. You will not be prosecuted. Go sit down, cooperate. You cannot invoke your Fifth Amendment right. And he relied on that. And I think that this court's decision in Stipetich really helps guide us here, because in that case, you had two defendants who were arrested, and even with the assistance of their counsel present, brokered a deal with a law enforcement officer who said, listen, if you tell us the source of this contraband, we won't prosecute you. And again, here are defendants, I don't know how savvy they were, but they were there with their attorney, and the attorney said, yes, go ahead and tell them that. And naturally, this court ultimately concluded that it's the district attorney's job to decide who prosecutes, not law enforcement officers. But the court still determined that that evidence should be suppressed because he relied on that. And as a matter of equitable principles and fairness, I think that we would have to assume that that for Mr. Cosby, again, I don't think he should be punished because he followed the advice, believed there was a deal, and invoked his Fifth Amendment right. Again, in hindsight, we certainly would have all done this very differently. But I think the fact that he did sit and gave the testimony, the only fair inference is that he did rely on the representations, and that it was done with the assistance of his attorney who testified. I understood through his criminal counsel, and I understood from through the criminal counsel from the district attorney that this was connected. He had to testify in order to not be prosecuted. And that's the best way he can answer that.
I'm sorry, I didn't mean to interrupt you. It's Justice Barrett. I want to follow up on Justice Doherty, and then I have an independent question. And I don't mean to nitpick, but there's nothing in my preparation that indicated that Mr. Cosby has ever indicated in his testimony or his protestations that he relied upon the alleged deal with DA Castor. In the trial court, and I noted this because, again, it's a partisan case, the trial court found Mr. Schmidt, who was his attorney Schmidt, who was attorney at that point, not credible. Found that his testimony was not persuasive. I can't recall, but indicated that he negotiated a deal with the National Enquirer and this settlement and et cetera, and just didn't believe that he had done this. And again, the first question I asked you was trial court discretion. Here again, you fall under the constraint of trial court determination of credibility, which is binding on us. So doesn't that sort of get you to the wrong side of Justice Doherty's question?
Well, I think you are absolutely correct that this court owes great deference to the trial court's credibility findings. They are not, however, unassailable. And I believe that the dispositive facts in this case, the ones that are not disputed, still lead us to the conclusion that at least the deposition must be suppressed. And those are that we know that Castor chose not to prosecute. We know that. Whether that promise was intended to bind future prosecutions, I suppose, is a credibility determination that the court resolved against Mr. Castor. But we do know at that moment he declined to prosecute He represented that in the press release, and that it was bound to or linked, there was some nexus to the civil case. And again, I can't create a formal writing that didn't exist. It just didn't exist. And again, we can look in hindsight and wish it did. I think we all do. But I think the reason it's troublesome for us is that we can't wrap our head around the fact, why would somebody sit for a deposition with prosecution looming over their head in such a serious matter? And I think while that may lead somebody to a different conclusion, for me, it leads to the conclusion that, well, clearly there must have been an understanding and a confidence that if he did so, there would not be a prosecution. And that is, I guess, the best way I can answer that question.
I think that's fair. Let me ask you one last question, and I hope I'm done. You, as part of your able presentation, detailed the nature of the relationship between the defendant and the victim. And one of the exceptions in 404B is absence of mistake with specificity. Why isn't it reasonable that the evidence of the prior bad acts comes in to show that Mr. Cosby was not mistaken, that this was a consensual relationship?
Well, I would point out that using absence of mistake to show some type of mens rea, if you will, because that's what we're talking about, is unconventional, to say the least. There's a dearth of authority in this Commonwealth and elsewhere that absence of mistake is an exception that applies where the physical elements of the crime are not in dispute. You usually see it, of course, when a defendant says, well, my conduct was an accident or it was a mistake. And that's sort of the traditional scenario. Here, the prosecution is using it really for a novel idea that it allows us to look into Mr. Cosby's mind and determine whether or not whether he could have mistakenly assessed her ability to consent. And our position is, and if the court, I'm sure the court has read the briefs and will, Professor Infiniti wrote an entire article about the use of prior bad act evidence for mens rea purposes and how it's really kind of a slippery slope because it's just it's not as predictable, the mental component. Just because someone exercised a particular intent 5 times before 15 years ago does not necessarily mean he exercised that same intent or was under the same belief system. So we'll say that. With that said, there is authority from Commonwealth versus Tyson out of the Superior Court, which for the reasons we've addressed in our brief, we have said we believe is wrongly decided. But apart from that, it's our position that it is highly distinguishable because unlike the defendant in Tyson, Mr. Cosby had not been accused of those prior bad acts before the incident with Ms. Constant. So one of the focuses that the court had in the Tyson case was that there the defendant had been accused, he had lodged a consent defense, he had been prosecuted. So he certainly had knowledge. He suffered the penal consequences of his behavior before, and he was on notice that when he had this similar encounter, that he should have known better. But here we have a very distinct scenario where Mr. Cosby did not face any of these accusations prior to the charged offense. That it came after the charged offense. Moreover, we don't know whether Mr. Cosby would even allege consent as to those 5 prior acts. The record is silent on that. He could say, I don't know who that woman is. I never met that woman, or we never had any sexual relationships. The record is simply silent on that. So I think to sum up on this point, using absence of mistake as an exception, or excuse me, to use prior bad act evidence to show a mens rea, in this case, which is what the prosecution is trying to do, has a number of pitfalls that are identified by Professor Infiniti. It's just not as
Counsel, Ms. Bongini, this is Tom Saylor. The professor concludes very tellingly that the trier of fact can reason from the starting point of the uncharged crime to a conclusion about the mens rea of the charged crime only through an intermediate assumption about the accused character or propensity. That's the difficulty with this approach, isn't it?
Yes, it is. And that's
ably carried. The jury is going to have to make that leap. And that's the overtly difficulty with applying this doctrine.
That's absolutely right. That the jury has to make a intermediate determination about tendency or disposition, that because he acted with an alleged mens rea in the past, he had a tendency or disposition to do so on the charged offense. So in that sense, that is why, frankly, prior bad act evidence just doesn't really work very well when looking at mens rea types of issues, as opposed to issues that involve physical acts, which are far more predictable.
Now, can I ask you if you could sum up in a word or two as we're going to move to the common law?
Yes, Your Honor. Thank you very much. I would just point out that prosecuting agencies in this Commonwealth and states across the nation have chipped away at the general prohibition on prior bad act evidence for decades. And with this case, they truly seek to obliterate it. This court should rule to protect the time-cherished rule, not just because it's Bill Cosby or to right a wrong in this case, but because the constitutional guarantees of the presumption of innocence, the burden of proof, and even due process that frame our criminal justice system are at stake. And I thank you all.
Thank you. We'll hear now from the Commonwealth.
Thank you, Your Honors. Good morning, Chief Justice Saylor, Justices of the Supreme Court. May it please the Court, Adrienne Jaffe on behalf of the Commonwealth. I will be arguing the prior bad act issue. My colleague, Deputy District Attorney Phelan, will be arguing the alleged non-prosecution agreement. Your Honor, the prior bad act—
why is that? Is it, why do we need two lawyers?
Well, we filed a motion to split up the argument, and that motion was granted. So since I've been working on the prior bad act since the inception of this case, and Mr. Phelan has been working on the other issue, that's why we submitted our motion.
Thank you.
Thank you, Your Honor. The prior bad act evidence in this case, the defendant's drug-induced sexual assaults of 5 women, was relevant under 3 separate grounds. First, it was relevant under the absence of mistake exception under 404B to rebut a defense. In this case, the defense was consent. That is, it had a tendency to prove that the defendant was not mistaken about whether or not Andrea Constant was conscious enough to consent to any sexual contact. The evidence was also admissible under the common planner scheme exception. The defendant engaged in a years-long signature predatory pattern of seeking out and intentionally isolating young women so he could intoxicate them for the ultimate purpose of sexually assaulting them. So his plan was to intoxicate young women to eliminate consent. And thirdly, Your Honor, I would submit that the evidence—
Counsel, I apologize for interrupting you, but you keep saying the 5 women were sexually assaulted. It's my understanding that the last individual, the young woman that was interviewed for a part on the Cosby Show, there's no allegations of sexual contact. It's that she took a medication, fell asleep, and woke up.
Yes, Your Honor.
So share with me, how can you represent that there is sexual abuse on that person when the record evidence indicates just the opposite?
Your Honor, I would submit that the signature was isolating and intoxicating young women for the purpose of sexually assaulting them. And I would— Lisa Loveland, you're correct, Your Honor. She did in fact testify that she has no recollection of being sexually assaulted. She has no recollection of what happened after the defendant gave her a drink. She drank it after the defendant asked her to sit in between his legs on the couch, which she deemed to be odd and inappropriate. And then he began stroking her hair. Then she basically passed out and was unconscious until she woke up 2 days later in her apartment. But the bottom line is that the part of the signature is the entirety of the contact and the conduct between the defendant and these victims. And the
Ms. Jaffe, Tom Saylor, but that conduct you described, the steps, the young women, there's literature that says that's common to 50% of these assaults, thousands of assaults nationwide.
Your Honor, it's the mentor-mentee relationship. It's the fact that the defendant was built trust in his victims because of their mentoring relationship, because of
I
his
understand
status.
that, but yet you see, if that was the case, maybe you dispute the literature, but in the briefs they cite treaties and literature that says that's common to 40 or 50% of these assaults nationwide, the number in the thousands.
Well, perhaps it is true that 50% of sexual assaults are drug-induced sexual
So
assaults.
how can that be a common scheme?
According to what's in the defendant's brief, there's been no evidence at trial as to any statistics, and I would submit that's not part of the trial record, so that shouldn't be considered by this court. But Your Honor, the defendant engaged in a pattern of seeking out young women. He met them through their employment or their career. He offered to mentor most of his victims. There was a built-in level of trust because of his status in the entertainment industry and because he held himself out as a public moralist. The victims were legitimately in the defendant's presence because he invited them to the location within his control under a guise. And each incident occurred again in a location within the defendant's control, so he could intoxicate these people, carry out his plan without any interrupted discovery. And then he intoxicated them, waited until they were unconscious or otherwise unable to consent to any sexual assault, and then either sexually assaulted them, or in the case of Lisa Lott Lublin, he engaged in what I would submit as untoward sexual conduct, inviting a young woman to sit in between his legs and then starting to pet and stroke her hair.
Counsel, this is Justice Donahue. What are you describing? A signature? A signature crime? Is that what you're describing to us? Because
Your Honor, I am.
Let me just.
I apologize.
Adjusting the question. The assault that took place here, the alleged assault that took place here, took place in the defendant's home after an 18-month relationship with with Miss Constand, after meeting her mother, after going on trips with her. I mean, you know, if you're talking about a signature, you better incorporate all of the facts that we have in the case that's on trial with what you are offering as a signature, because frankly, I don't see it.
Your Honor, certain differences. Well, let me say this first. Miss Constand was not the only victim that the defendant had a lengthy relationship with. He had a several years long relationship with Lisa Lott Lublin. He had a relationship with Janice Dickinson. She had been to his apartment in New York prior to the assault, and he sought to mentor her. He also had a relationship with Shalon Lasha. He had spoken to her grandmother on the phone. He had come over to Shalon Lasha's house for dinner. And he also had a relationship with Heidi Thomas. He spoke to her on the phone on numerous occasions. So it's not true that he only had a friendship or relationship with Andrea Constand. And in any event, Your Honor, the actual relationship is just one of many factors to take into consideration in making a determination as to whether or not something is a signature. There are certain distinguishing factors that are inconsequential to whether or not a crime is a signature or whether or not absence of mistake applies. That is, whether or not the defendant was mistaken in assessing Ms. Constand's ability to consent to the sexual assault. And I would submit that the absence of mistake exception, which was the main exception that we proffered this evidence for, has a lesser threshold of admissibility than does the common planner scheme. Whereas the common planner scheme, admittedly, as is pointed out in several opinions from this court, and as the defense points out in his brief, there is, in fact, some conflation between in common planner scheme, for instance, whether or not it's being admitted solely to show a common plan or whether or not it's being admitted for identity purposes.
Can I jump in, counsel? Can I jump in on that for a moment? You've referred to an alleged signature aspect. Identity is not an issue here. So where are you going with this signature allegation? That's number one. And number two, with respect to your repeated argument about absence of mistake, how does that factor in here when Cosby never argued that he made a mistake or that he made an accident or something like that? He argued consent. Can you answer those two questions for me?
Sure, Your Honor. In terms of consent, I would submit that absence of mistake is routinely has been admitted in numerous cases or several cases in this Commonwealth to demonstrate an absence of consent, and I would submit that was the defense here, an absence of consent. And numerous cases such as Commonwealth versus Tyson have allowed evidence to come in to show absence of mistake. And in that case, Commonwealth versus Tyson, the defendant was on trial for rape of an unconscious person, and a prior bad act of a rape of another unconscious person came in, and the Superior Court, sitting en banc, found that that was in fact admissible to establish a lack of consent. And also another case, which was not cited in my brief, Commonwealth versus Kiersgaard, that was a 1990 Superior Court case. That was a situation in which a defendant was on trial for raping a teenager, and evidence came in of a prior rape of a teenager to came in for absence of mistake to show that he was not mistaken as to whether or not the victim consented. So there are cases in this Commonwealth that allow for absence of mistake to show a lack of consent. And in any event, Your Honor, admitting other act evidence to rebut a defense is a staple in Pennsylvania jurisprudence. And the effectiveness of the rebuttal here is enhanced by a distinct pattern of similar crimes indicative of the common conscious design here. For instance, in Commonwealth versus Buskowski, that was an opinion of this court. It was a bathtub drowning case. The defendant was on trial for the murder of his wife, and incidentally, his prior wife died the same way in a bathtub drowning. And in that case, the court found that the evidence was admissible of the prior wife's drowning under the absence of mistake exception to rebut the defendant's contention that the act was the result of a deliberate act. And in Commonwealth versus Hicks, Your Honor, as well, the prior that was a homicide case, which I'm sure this court was aware of. It was just a few years ago. And in that case, one of the reasons why the prior bad act evidence came in regarding 3 prior assaults was for absence of mistake, to show that the victim in that case didn't die of simply a drug overdose, but rather it was a deliberate act of the defendant. So what we're doing here in proffering this prior bad act evidence to show an absence of mistake is nothing different that has been done in this court in numerous occasions to rebut a defense that's being proffered in this case.
But counsel, back to Justice Weck's question. The defendant here didn't claim that he made a mistake in thinking that there was consent. That's an editor by the Commonwealth in order to create a basis to assert this evidence.
Well, Your Honor, I disagree, because perhaps it's just a matter of semantics, but the defendant was claiming consent. That was the defense. So by implication, he's saying he was perhaps mistaken in assessing her ability to consent. So I would submit that they would be the same thing.
He wasn't asserting that at all. I mean, he was asserting consent. In order to proffer this evidence, the Commonwealth twisted that defense into, oh, now we're going to prove that there wasn't a mistake about the consent. They're really two totally different propositions.
Well, with all due respect, Your Honor, I don't see them as being different. However, also, the evidence was also admissible under absence of mistake to show that Andrea Constant was not conscious enough to consent.
Let me ask you this, counsel, before we get much deeper into this. Why did you need this evidence? You had you had the complainant who is capable of testifying, who did testify, and the question in this case was, who is the jury going to believe? The complainant who did testify, or the defendant, who had a different version of what occurred here? Why did you need prior bad acts evidence at all?
Your Honor, it was needed for several reasons. Number one, it was needed to corroborate the victim's testimony that she did not consent. In order to convict the defendant of aggravated indecent assault, the Commonwealth had to prove that the defendant engaged in non-consensual penetration of Andrea Constant's vagina. Thus, as I indicated, the main issue became one of consent. Without this evidence, the Commonwealth would have had to largely rely on the uncorroborated testimony of Andrea Constant regarding the lack of consent. And Tyson made clear that this case, or this exact scenario, created a heightened need, noting that if the evidence in that case was excluded, the Commonwealth would have to rely solely on the uncorroborated testimony of the victim to counter the defense consent. Now, I will say there was other corroboration of Andrea Constant's testimony, but in terms of consent, there was no other corroboration of her testimony. And in addition, Your Honor, the victim—
Ms. Jaffe, excuse me, but you really, I think, you focus on the lack of consent on the part of the victim, but you're really trying to demonstrate appellant's knowledge of that lack of consent. And that was the argument of the appellant, don't you see, when you use that doctrine, absence of mistake. You know, you want to inject that before the jury to show that the defendant lacked knowledge of the lack of the victim's consent. And I come back again to the problem with that type of testimony, legally and within the literature. That's going to require a jury inference into the appellant's mens rea, which is really what you're focused on. What was the defendant's state of mind? And I'll read you again that the trier of fact can reason from the starting point of the uncharged crime to a conclusion about the mens rea of the charged crime only through an intermediate assumption about the accused's character or propensity. And that's the legal issue that confronts this court in terms of the sanctity of the verdict.
Well, Your Honor, I don't think that's an inference that needs to be taken or adopted, because the whole absence of mistake, it's coming in to show the lack of consent, and the consent—
No, it's coming in to show the mens rea of the defendant with
Your
respect to lack of consent.
I would submit that it's coming in to establish the actus reus, because part of the aggravated indecent assault, the actus reus of it is not just the digital penetration, but it's the digital penetration without the victim's consent. That's part of the actus reus. And to bring in absence of mistake, I would submit it's simply demonstrating that Ms. Constant was not consenting or could not consent because of the intoxicants that were provided to her.
Ms. Jaffe, it's Justice Todd. You referred to, when you were discussing the prior bad acts, I thought I heard you refer to them as prior crimes. Did you do so?
I don't know if I did. It was inadvertent, and I generally say prior bad acts because, and I'm well aware of the rules. It doesn't have to be a conviction in order to be a prior bad act. It can be crimes or other acts. And in this case, there are other acts. I've made no— if I did make an assertion that it was a crime, it was inadvertent, and I apologize.
That's all right.
But I will say that there doesn't need to be a conviction, prior bad acts, to come in, as the title of 404B makes clear. Other acts are sufficient.
I understand that, but any of these prior victims report, prosecute, or go to court in any way over the incidents?
None of them went to court anyway. In terms of reporting, they did not report the incidents to the authorities for many years afterwards. However, many of them did in fact report them to some people. For instance, Shalon Lasha, she was the 17-year-old that the defendant intoxicated and sexually assaulted in a hotel room. Immediately afterwards, she drove to her guidance counselor and told her guidance counselor what happened. Janet Dickinson, she confronted the defendant the next day, actually, and basically said, "What the heck did you do to me?" And then after that, she in addition, she told like her publicist, she was an actress, she told other people, including Dr. Drew Pinsky, when she was on Celebrity Rehab show with him. This was a couple years after the incident, well before the Andrea Constant incident. So she told him, she told her publisher when she wrote a memoir, and in fact, she wanted to include it in her book. However, after speaking with the legal team, they said, no, we can't put this, that he raped you and intoxicated you. And that was years and years before the assault came out. Several of the other prior bad act witnesses, one of them, when they went home, they told their roommate, another one told their sister. But in terms of reporting it to the authorities, no. And as Dr. Ziv testified, she was our the sexual assault victim behavior expert. A lot of times these people don't report right away. And she explained all these rape myths that the defendant sought to debunk in its cross-examination of Andrea Constand. So she explained why they don't report these things to the authorities. Who's going to believe me? I'm saying Bill Cosby sexually assaulted me after intoxicating me. So that's why they didn't go to the authorities.
Counsel, share with me your position of the use of prior bad acts dating back as far as 37 years ago to 1984 with Heidi Thomas, and how that is probative of current.
Okay. First of all, Your Honor, I do want to clarify something. I know you're saying 37 years back, but the time is from the time of the incident to the time of the Andrea Constand assault, not the time of trial. So they were actually, the first assault that we introduced was in 1982. The assault on Andrea Constand was in 2004. So it was 14 to 21 years. And that's just, I know the defendant says 15 to 22 years in its brief, but the assault on Andrea Constand occurred in January of 2004, so you don't count January. So I will answer your question, but in terms of 14 to 24 years. First, I want to point out that there is no bright line for what constitutes remoteness. The determination should be made on a case-by-case basis based on the unique facts and circumstances of each case. There has never been a case that unequivocally says 10 years is too long, 20 years is too long, because you have to consider the facts of each case. And focusing solely on the time lapse is improper because remoteness is only a single factor the court is to consider. And importantly, the remoteness or the time period is inversely proportional to the number of similarities between the incidents. And here there are abundant similarities, as I detailed, and I will be happy to detail them again, but they are set forth in my brief. And I also want to point out that numerous cases have allowed in prior bad acts for the time frame around the same time of this case. For instance, in Commonwealth versus Lucktish, that was a Superior Court case, the court allowed in 19-year-old sex assaults, and they were sex assaults going from 19 to 14 years before the current assault. And in that case, the court also let in another sexual assault, eight years before that. And Commonwealth.
Counsel, I apologize. I understand the case. So I understand. I guess the question or concern that I have in Pennsylvania jurisprudence, what you're advocating is that 3 decades of an alleged prior bad act is admissible in a trial because there's no ceiling as to the staleness or remoteness. Yet we have to balance that against our own rule of 609 of evidence, in which the use of a conviction is considered stale in the impeachment of a witness, unless there's the other argument, unless it's more probative. So how is it that we are to digest the use of an alleged act is admissible 14 to 37 years later, yet we don't look as a trial lawyer and as a trial judge? I'm sure you, as a trial lawyer, have been exposed that when you try to introduce a stale conviction, it's objected to and usually sustained. How is it that what you're really asking us to do is to place an alleged prior bad act in being a superior position in its introduction into a trial as opposed to a conviction? I'm really struggling with that position.
Okay, and I'd be happy to answer that. But I first want to say I would disagree that it's routinely not allowed in if it's over 10 years old. And a case in point was in this case, one of our prior bad act victims had a prior conviction that was over 10 years, and that was allowed in by the trial court. But in any event, the distinction, I would say, in this case is, in your example, we're talking about a single conviction. Here we have a recurring sequence of events. And that's why it's important when you're considering remoteness, you don't consider simply the one prior bad act in isolation and only in relation to Andrea Constant, the case law makes clear that you must consider them all in relation to each other. So in this case, the ones that were introduced, we had 2 in 1982, 1 in 1984, 1 in 1986, and 1 in 1989. And again, I want to stress that you don't look at these in isolation, and this shows that there was a recurring sequence of acts by the defendant over a continuous span of time, as opposed to random and remote acts, such as in your example, a random and remote conviction for 10 or 20 years. So while we have the 14 to 21 year gap, when the court had this evidence to consider, the gaps were less than 14 to 21 years because we proffered 19 witnesses. And when the court made his determination as to whether or not this evidence was relevant, the court had all 19 of those witnesses to consider. So he had the time frames of all those witnesses that closed up some of the gaps to more sufficiently demonstrate this recurring pattern or this recurring sequence of events of the defendant isolating, intoxicating, and then sexually assaulting young women.
Counsel, that segues me into one additional question.
Sure.
Let's talk about that. My understanding of the facts of this case was that the judge, Judge O'Neill, permitted the Commonwealth, out of those 19 witnesses, to choose any 5 and then introduce them, correct?
No, that's not correct, Your Honor. The court allowed the Commonwealth to choose 5 out of 8. So we had 1 to 19 listed in chronological order, 19 the closest to Andrea Constand's assault. He said we could choose any 5 from number 12 through 19.
Counsel?
While he said that, he also stated that he believed the evidence was all relevant. All 19 of them were relevant, but in only letting us bring in 5, he was weighing the probative value of this evidence against any potential for unfair prejudice.
Counsel, Justice Baer, and again, I'm just trying to follow up. Most of the argument today has been whether or not this evidence falls under 404B and is admissible at all. But I think I started this argument an hour ago by asking your worthy opponent about abuse of discretion. And I'm still there to some extent. Did you advocated putting all 19 in? Is that correct? Oh, I lost you.
I'm sorry, can you hear me?
I can't hear you now. You advocated putting all 19 in.
We did.
All right. 150? Is there any point at which we're not trying whether or not the defendant assaulted the victim, but rather trying whether the defendant assaulted one of the other 19 or 18 or 5? And again, I recognize abuse of discretion is a broad standard, but you can still get to the point with evidence that's terribly probative that it's just too much and that this defendant did not have a fair trial.
Well, Your Honor, again, like
arguendo, it's admissible, but the amount of it is such that the weight was conflated the issue from whether this defendant did this crime to whether he did the other 5 or 18 or 19.
Well, Your Honor, in addition to the judge only allowing us to present 5, the court kind of acted as a gatekeeper during trial. After the first prior bad act witness, the Commonwealth, or excuse me, the defense moved to preclude that, to strike that testimony, and then she moved to preclude the next testimony. So the court was essentially revisiting the ruling, and he said on the record, you're allowed to have up to 5. So he made the determination what would have been unfairly prejudicial or what was too cumulative. And that's what the job of the trial court, to exercise his discretion and do that. And importantly, there's no bright line rule that 4 prior bad acts are too much, or 5 or 6. It depends on the facts and circumstances of each case. And there have been several cases in this Commonwealth that have allowed in more prior bad acts. For instance, in Commonwealth versus Frank, a Superior Court case, which I cited in my brief, a therapist was on trial for assaulting a young boy, sexually assaulting a young boy, and the court allowed in 6 prior bad acts to establish a common plan or scheme. And then in Commonwealth versus Arrington, which was a case from this court from a few years ago, Justice Baer, I know you wrote the opinion, and Justice Todd, you joined in the majority opinion. In that case, that was a homicide case, and the court allowed in prior bad acts from two previous girlfriends and then some prior bad acts from a man. But each of those girlfriends testified as to multiple instances of abuse, and the man testified as to several instances of abuse. So I believe about 12 instances of abuse came in. So although in that case there were only 3 witnesses taking the stand, there was about a dozen separate instances that were described. And the same with Commonwealth versus Lucktish and O'Brien, what I cite in my brief, sex assault cases. In them, only, I think, 2 prior sex assault victims came in. However, they testified as to numerous assaults that were committed on them by the defendant. Here, we only had 5 prior bad act victims. And while the defense says the prior bad act victims took up half of the testimony, that is not true. There were 25 witnesses that testified at trial over the course of 10 days. We had 5 prior bad act witnesses. That's it, aside from 2 corroborative witnesses that took the stand for about 3 minutes each. That was 2 days of a 10-day trial.
Ms. Jaffe, we're going to hear now from your colleague, Mr. Fallon, because we want to conclude this argument, which is gone on for a while.
Your Honor, if I might just take 2 minutes to address harmless error very quick, because I know that was brought up.
Yeah.
If I may. It's our position, Your Honor, that even if for some reason this court finds that the evidence, the prior bad act evidence was not admissible, I would submit that any error was harmless in light of the overwhelming evidence. We had Andrea Constand's testimony that the defendant provided her intoxicants, that those pills rendered her incapable of consenting, that she was incapacitated, that the defendant penetrated her vagina with his fingers. He put her hand on his penis and masturbated himself, and he fondled her breasts.
If that's true, why'd you need the 5 witnesses?
Well, Your Honor, there's a difference. This was our pretrial assessment of the case. We did not know at the time exactly how our evidence was going to go in. And while we said we needed this evidence, in saying that, the evidence was very important to us because the victim didn't promptly report, because we knew from everything that the defense did first time around and leading up to the trial that they were going to relentlessly and ruthlessly attack her credibility. And in fact, they did. And we also knew that they were going to call Margot Jackson, who was their super witness.
That has nothing to do with harmless error. So we're going to hear from Mr. Fallon.
Okay, thank you, Your Honor.
Good morning, Your Honors. Thank you for allowing us to split time. May it please the court, my name is Bob Fallon from the Montgomery County DA's office. I'll be addressing defendant's non-prosecution claim. He alleges that Bruce Castor in 2005 promised him transactional immunity and that he relied on that when deciding to sit and answer questions at a civil deposition. The trial court, however, after 2 hearings and hearing from the witnesses, found that there was no promise and that there was therefore nothing for defendant to rely upon when sitting for those depositions. Those findings and credibility determinations are supported by the record. That leaves this court, I'd submit, with no mixed questions of law or questions of law to answer. It is simply, the court does not have to reach the issues of promissory estoppel or any of the other legal or mixed questions that the defendant raises.
Counsel, could I ask you, counsel, pardon me, on that, assuming for the sake of argument that you're right about there being no binding agreement, there would, under any circumstance, not be any argument about the prosecutorial exercise of discretion here. That is to say, as memorialized in Mr. Castor's press release, that a decision was made by the DA's office not to prosecute this defendant. Since we're the Supreme Court, this case obviously has implications well beyond this defendant. What is the lesson that emerges from your position in this case regarding the reliability of prosecutorial decisions? What is the implication for the thousands of promises made by prosecutors across the Commonwealth every day or every week? Plea deals, immunity agreements, non-pros agreements, agreements to cooperate with witnesses, et cetera, in return for something, et cetera. If your office's word is not its bond, and we validate your position here, what is the lesson that emerges from beyond this case for all cases going forward in Pennsylvania? You understand my question?
I do, Your Honor. And the fact is, prosecutors are bound by contracts that they enter into, or if they do make a statement that a defendant reasonably relies upon, then the defendant can seek some relief. The question here, it doesn't really reach that issue because the only thing the defendant can point to is a press release that says that the prosecutor is not going to press charges. That same press release leaves open the possibility that the case will be reconsidered. In the press release, District Attorney Castor says, cautions all parties to this matter that he will reconsider this decision should the need arise. Not only that, but in 2015, he was interviewed by the Inquirer, and he told the Inquirer, I put in there, referring to the press release, that if any evidence surfaced that was admissible, then I would revisit the issue. And that is evidently what the DA is doing. So I think the lesson that this case would teach is that simply because a prosecutor announces he or she is not going to press charges in a case, without more, that does not give the defendant license to say, wow, that's transactional immunity. It's really prosecutor 101 that you do not close off cases, even if they go cold. You leave open the possibility that if new evidence is discovered, that you can then go back and live to fight another day in court. There is no reason for a prosecutor to just say, okay, I'm not going to press charges. Defendant's free and clear forever, no matter what turns up in the future. And no matter if a federal judge, as in this case, released a civil deposition and in an opinion said, this deposition reveals behavior that is perhaps criminal. Prosecutors should not and do not do that. They sometimes don't press charges in a case, but they never, in my experience, will just, for the sake of the civil case, say, we are never going to do that. And it's especially strange in this case because Castor ended this investigation while the investigation team was still strategizing on the next steps. And that's from Detective Richard Schaefer's testimony at trial. He said when he got the call that the case was closed, he and his team were still mapping out the next steps in the investigation. So
That's a call. That's a call. Just one brief follow-up. Can I just have one brief follow-up on my question? A sitting DA made a decision memorialized in a press release. You don't like that, you being the successor's office, that is. But why does that not bind you as the successor office?
Your Honor, I think because by its own terms, it's leaving open the possibility that it can be reconsidered. I mean, it's right in the press release, and there can be certainly, the court was talking about reasonable reliance if we get to that analysis. If we're just talking about the strictly the press release, nobody should reasonably rely upon that for transactional immunity. That would be a horrible precedent to set. To say that when the actual document says the prosecutor may reconsider it, that defendant can take that press release and say, I am forever immune. And then a court is later going to enforce that. That is not fair. That is not fair to the Commonwealth, and it's unreasonable for defendants to expect that. If they are, yes.
Sorry, it's Justice Todd. Isn't it fair also to look at Mr. Cosby's reasonable reliance on the agreement he believed he had, based upon the fact that he went forward with the civil deposition and put himself out there for those questions and did not raise any objection at that time or invoke his right to remain silent? Isn't that indicia of reliance on what he believed to be an agreement?
Well, Your Honor, it is not. And I'd also just point out that the trial court did not believe that it was indicia of reliance. And that's really the key issue here, whether the trial court had support in the record for its findings. And I'll explain why it's not indicia of reliance on this so-called promise from Castor. Defendant sat for a police interview with multiple detectives during the investigation, and he gave an exculpatory account of his interactions with Andrea Constant. He did not invoke his Fifth Amendment rights. And his lawyer, Schmidt, who the court deemed rejected his testimony, but Schmidt said that he had interviewed defendant before the detective interview, and he felt confident that the defendant would not incriminate himself. That's why Schmidt let him sit for the interview, because it served his client's interests. The defendant was able to get through that interview and end up giving an exculpatory account. Not only that, but he then, with Schmidt negotiating the deal in detail, in writing, in multiple stages, and exchanging of papers with the National Enquirer lawyers, negotiated for the defendant to sit down with the National Enquirer after the investigation and talk about Andrea and the whole incident. Again, he did not invoke his Fifth Amendment rights. The defense team, which was consisted of John Schmidt, Patrick O'Connor, and Walter Phillips. I mean, we're talking about an excellent defense team. They let him sit because it served their best interests. And so if he had invoked his Fifth Amendment rights at the civil deposition, he would have faced negative consequences. And in fact, the victim's civil attorneys, Troiani and Kivitz, they both testified, we wanted him to invoke. It would have been better for our case because, one, the jury would have only have heard from Andrea, and two, we would have had a favorable instruction that would have allowed the jury to infer that because the defendant invoked his Fifth Amendment rights, his testimony would be unfavorable. So defendant sat for the civil depositions, tried to give an exculpatory account, and essentially did, although he slipped up and made statements that came back to haunt him. But he was trying to do exactly what he had done before. He sat for the interview with detectives, with the National Enquirer. He thought he could get away with it. His defense team thought he could get away with it. He was trying to avoid negative consequences of invoking the Fifth in this situation, and it backfired on him. That's what happened. There was no, and one important point, and I think Justice Doherty mentioned it earlier. The defendant, by his own allegations, believed he had transactional immunity from Castor for Andrea Constant. That's it. No other victims. Yet at the deposition, he would not answer a lot of questions about Andrea. That's not consistent with someone unburdened by transactional immunity. He was compelled to do so by the federal judge. And yet, importantly, and this has never gone rebutted by the defense or even explained, is that defendant openly answered questions about other victims in other jurisdictions. Those victims would not have had any, he would have not had any immunity for those victims. Castor could not grant immunity for victims in California or New York or Las Vegas. So why explain that conduct? It's inexplainable if he sat because he had thought he had transactional immunity for Andrea Constant. So I don't think there was any actual reliance here. And that is in fact what the trial court found. And I want to be considerate of this court's time, but just in closing, I'd say ask the court to, this court has established the deferential standard of review for credibility determinations and fact findings for a reason. The cold record does not capture everything that transpires in a courtroom, from the mannerisms, tone of voice, gestures, expressions, the change in demeanor as a cross-examination shifts from the beginning to the end. All these things aren't captured in the cold record. And as someone who was there that day, both those days, I can safely say that this cold record does not capture everything that happened. But even despite that, if you read this record, there's ample support for the trial court's fact findings and credibility determinations. And that's really as far as this court, I would respectfully submit, has to go. This is an issue for the trial judge, and he properly resolved and denied this claim.
Thank you, Mr. Fallon. Unless there are any other questions, we'll conclude this argument.
Thank you, Your Honors.
Thank you, Your Honors.
Take a 5-minute recess and call the next case.
All right, guys. All right. Let me see what they're going to do. All right, guys, feel free to go ahead and unmute your mics if you are there. So it looks like they're going to take a recess, a break. Let's see. Let's start with you, Gavin. What are your thoughts? You're the attorney here. What do you think so far? Your mic.
Mute.
Okay.
Hold on a second. I was trying to, I don't know why my green screen went off. All right. Oh, damn it. Okay, because I'm actually live streaming with you, and I'm live streaming on my other channel because I wanted to play it on there as well, and give my commentary. Can y'all hear me? Okay. All right. So what you essentially saw, Nicole and guys, my commentary, I liked how it went. Especially you saw how they were grilling the prosecutor. I can't think of her name.
Yeah, I didn't even.
Was it with regards to the 4 bad act witnesses about the mens rea? And what got me was at the very end when the Chief Justice, his name isn't Dorothy. I don't think it was Dorothy, but the Chief Justice Saylor. He asked her about it. Why would you put 19 women? And she says, well, we knew they were going to attack her credibility, and he drugged this woman. He made her masturbate, and he forcibly masturbated to her while grabbing her breast. He says, well, if all you needed was the complaint, why did you add the other prior bad act accusers? Why do you need all 5 of them then if you had the complainant? That one caught me. I started laughing. I wasn't a fan of the and even when you saw Dorothy, because he asked her Bogine about Bill Cosby, isn't he knowledgeable about the about self-incrimination and the Fifth Amendment? Well, Bill Cosby is not a lawyer. He's not an attorney. He doesn't have legalese like I do or any other else. He's relying on the guidance of counsel. So when he makes those comments and he gave that testimony, he was under the impression that he had a Fifth Amendment right against self-incrimination because the prosecutor said in the press release there would be no charges. What they also failed to mention was that there was an email, if I'm not mistaken, that was Castor and Schmidt, Bill Cosby's lawyers at that time, where he said there would be no prosecution. So that is in writing. What they're talking about, promissory estoppel, in regards to, he relied on that to, in Louisiana, we call it detrimental reliance as well in contract law. Contracts do not have to be in writing to be effective. Like I've told you guys before, if you make an offer to someone and they accept and they do conditions on that, then you can be legally bound by the court if it goes to court that, hey, this person did all of the necessary steps that you requested. You promised him to give him such and such in exchange for that, those actions. As long as it wasn't against public morals or against the law, then it was effectively binding. So, but I wasn't a fan of the last argument with that last prosecutor in regards to the the promise by the DA. I think he has a great chance with regards to the prior bad act, because you even saw the female justice that said she couldn't see it. Like, she couldn't see how you could make that connection with regards to the mens rea. Mens rea meaning your mental state of the defendant, and actus rea is the actual act. Bottom line is, I think, for them to even hear the argument to beginning, to grant the appeal, meaning to grant the hearing, was an indication that he was going to be vindicated. I'm not there yet, but I like the way it went
your
so
thoughts,
far.
Drew. What did you think?
I thought this went surprisingly well. I mean, it surpassed my expectations. I mean, you and I, Nicole, we've seen the worst in court, and I just wasn't really expecting too much. But you could tell that they weren't really buying the prosecution. They weren't, and they pressed on that. And I was surprised to say, wow, they're really, grilling them. And I think they are very aware that they had such a weak case, that they did extra stunts, like include these 5 additional women. So they're like, if you had this, this, and this, why did you need these 5 prior bad acts? And, I thought that went very, very, very good.
Right.
I didn't like the last half. They seemed like they were giving him a lot of deference, and he was just speaking. I don't know if that meant that they were listening and convinced by what he was saying. You could tell that the Bonjean, Cosby's lawyer, she wanted to interject. There were some things that they were just letting him go that I objected to, but I think overall this went a lot better than I had thought, and I think they're thinking about the legal precedent if they let this thing,
Right. And yeah, and compared to when you went to the appeal with the lower courts, totally different tone.
Oh, yeah, guys, that was a sad sight. That was a completely different experience, and we were sitting there, and they were just hammering. It was the the opposite of what you saw today. In the appeal court, they were hammering Mr. Cosby's defense, just beating them up, and I'm just like, wow, it was like a face palming moment. And the prosecution was just talking and talking and talking, and then they were just talking about the 5 prior bad acts like gospel. They were talking like it was fact, and the fact that these were not convictions and they were not given due process like was not mentioned. They were just, and it seemed like the judges at that time were also co-signing that, just talking as if the prior bad acts were gospel, and the defense at the time didn't really put up a fight against that. But I think overall today kind of surpassed what I was expecting. I think this lawyer is doing very well, and she's still playing within by the rules. She's not really because she can't.
Yeah,
but
she has to keep it right.
But you can't be emotional with it. It's business, so you can't get caught up in your emotions. You gotta nail the facts with it, and they took the most pressing issues, the most poignant points, which is the prior bad acts and the prosecutorial agreement. Keep in mind also, some other issues could not be raised because it got waived in the the lower courts. Remember the audio recording that they found out was edited. Well, they could not obviously make that argument in the appeals and say Brady violation because in the first trial, they allowed that to go in without objection. So, and that was something that really should have happened. And I even had conversations with, as you know, seeing Nicole, I've had Scott on the show. He said that, silly me, we didn't do our job with that. Same thing, So all of this stuff, though, the prior bad act witnesses, I think they were, especially the judge, you could see who was on the side of Cosby. I think the female judge and Barr were agreeing with it, as well as the Chief Justice and even Doherty, because at first it looked bad when his question, when he interrupted Bojan, but then you saw he kept interrupting this prosecutor. So they took issue with some stuff.
I was worried at first when he asked that question about, well, wouldn't he know? And I'm like, Bill Cosby, yes, he may be educated, he may be an entertainer, but he's not a lawyer. Okay, like I think this is this misconception that people have about him. Yes, the man is intelligent and whatnot, but he is not an attorney. Okay, what were your thoughts, Rich? I'm sorry, Rich.
Yeah, Rob, that's fine. That's good. I'm very happy. He's going to walk. I'm gonna tell you why he's going to walk. Because they got a lot of sense at the Supreme Court level, it seems. And also, what happened on September 23rd this year with Breonna Taylor, right? Y'all remember Breonna Taylor, that decision not to go after the cops? That was the 65th anniversary of them letting Emmett Till's killers go. Roy Bryan and his brother J.W. Malum. Today is the 65th anniversary of the Montgomery bus boycott, which happened in Montgomery, Alabama. Bill Cosby was tried in Montgomery County, Pennsylvania.
Right.
Okay. So we got to understand why platforms like this is so important to understand, because you're not going to get this type of information in the so-called mainstream, on fake news media, that Bill Cosby is walking because there was no evidence. There should never been a trial. He had an agreement through the email from the last DA. The last DA, from my understanding, had an email saying we will not try you if we interview you. And Cosby is only guilty of being black and a man and trying to help his people. And for our people to allow one of us to go down this way is disgrace, because we didn't have a strong media presence. Like I talk about Ida B. Wells. By herself, about 12 years, she led a one-woman anti-lynching crusade. She had a newspaper office in Memphis, the Free Speech and Headlight.
Right.
One of the first investigative journalists in the country, black or white, a black woman who was born into slavery back in July 16th of 1862. When she found out the truth about what they were doing to black folks with lynching, because lynching was a form of, a lot of people that were lynched were business people. A lot of black folks that were lynched were business folks, right? It wasn't because they were rapists and all this stuff, because they had business, like the People's Groceries lynchings in Memphis in 1892. Thomas Moss, one of her dear friends, she was the godmother to his daughter. He was lynched, and him and his two buddies were lynched for being successful businessmen who out-competed the white grocer across the street. That's why they were lynched. And Ida B. Wells, his last words were, "Tell my people they cannot get no justice here, go west." So Ida B. Wells in her newspaper told black folks to leave Memphis and go west, and 6,000 black folks left. And a lot of them went, and guess where? Tulsa, Oklahoma, Black Wall Street. And what happened in 1921? So every time black folks try to do stuff, they always taking us out. You got to think about how powerful we are. You think about somebody like Paul Robeson, whose father was born into slavery, was a minister from Princeton, New Jersey. Paul Robeson was a lawyer. He graduated at the top of his class in Columbia University ahead of Thomas Dewey, two-time presidential candidate and former governor of New York. This man spoke over 20 different languages fluently, was an all-star in terms of an amazing singer, activist, all this stuff, but he was punished for being outspoken and a proud black man. You know, Malcolm X used to listen to him speak on the radio to learn how to do public speaking. That's who Paul Robeson was. He trained the Harry Belafontes and the Sidney Poitiers, but we don't talk about people like him. Like Dr. Randy Short said, we love our traitors but hate our heroes. Bill Cosby, regardless of his flaws, is a hero or a hero. He did a lot for black folks, but we don't love the folks that stand up for us a lot of times. And to serve black folks is to love black people, because a lot of us don't love ourselves.
Yeah, it was something to see. I keep
Ron took it to church.
Huh?
I said, Brother Ron took it to church.
That was an angry black man. I don't care no more. I can't have it no more. I'm gonna give it.
Certainly did. I am enjoying all. Shout out to Brother Ron. Thank you so much. I'm going to have Frank. I believe his last name. I don't want to say his last name, but his name is Frank. He asked to be a part of the panel. He's a defense attorney. So I'm just waiting for him. He wants to give his thoughts as well. So we welcome him. I sent him the link. Hopefully he can get on. Oh, here he is. I'm sitting up here yapping. Frank, is that you?
Yes, it is. Hi, Nicole. How are you?
I'm good. How are you? So what were your thoughts? What were your thoughts?
Okay, the issue is that anytime you have a case and you say that a person has been involved in crimes in the past, a jury cannot adequately assess that information. They are likely to say, because he has been accused of doing this 5 times, 6 times before, he's definitely, a guilty individual. However, you cannot say that in law. That's why the opposing side, the prosecution, had to make an application to admit that. However, that application should not have been allowed because it's a highly controversial and it should not just be admitted. Essentially, it's prejudicial. It's prejudicial because of the fact that any jury can pick any prior instance and say, in that instance, he was guilty there, so we will just convict him for that, as opposed to the actual crime that he's been accused of and at trial for. So it was too many instances and should not have been allowed. That's why the court will likely kick that out. However, even if they kick out or state that the trial was not conducted.
I'm so sorry, guys. I think they're back. They're back. I'm so sorry. I'm going to back out and then we'll come back. I'm sorry about that, guys. Bear with me.
I think it's another case, Nicole.
Oh, it's another case? Okay.
I think they moved on. Let me see.
Okay.
I think they moved on to another case.
Oh, okay. Okay. That's right. All right. Well, continue. I'm sorry.
Sure. And And the last thing I was about to say is that even if they say they would like to kick out all of the evidence before in the past, they don't essentially have to agree to acquit him. They could simply say that the case should be thrown back down so that he'll be tried again in court.
Right.
So
Right.
people have to understand that just because things were done wrong in the first trial does not mean everything is over. No, they could say try him again.
Right. I guess that should be. I can see that as a possibility.
Well, let me say this too, and good morning to you, Counselor Frank, as well. What Frank is talking about is basically they don't have to acquit him in saying throwing out the conviction, but they could still throw out the conviction and say remand it to the trial court, meaning that they can bring in the prosecutors can retry this case again. We have a situation here in Louisiana, in New Orleans. You guys probably heard of the Cardell Hayes, Will Smith shooting that made national news. Cardell Hayes is going to be granted a new trial. Basically, his conviction of manslaughter, I believe he got 40 years, is being overturned because Louisiana finally added unanimous juries, and he was convicted on a 10-2 vote. So as a result of that, the new law that is in place, his conviction is going to be overturned, and he will be likely, because it's a high-profile case, whoever the new prosecutor is going to be, whether it's Jason Williams or Kiva Landrum here in New Orleans, they're going to decide whether or not to bring that to trial. But he could be released on his own recognizance until then because there's no conviction. I don't know if this Montgomery County would likely try this case again because of the amount of monies that it took to prosecute Bill Cosby in the first place. They asked Cosby to pay for the court fees and costs for this thing. And I don't know if Andrea Constant wants to even come back. Even Scott mentioned that when I spoke to him on the phone a while back, saying that if this went to trial again, meaning it ended in a mistrial, there was a likelihood she was not going to come back and testify. Either way, if they do get a new trial, I'm praying that a new judge gets appointed on this case because O'Neill does not need to be on that.
Right. No, he doesn't. Not at all. Not at all.
They need to put it in a new section. He is, and I stand by it. Normally, you can't accuse a judge. You have to be respectful to attorneys and lawyers. But, the bottom line is the facts were the facts. He was clearly biased by this. Tom, even stated that publicly, saying that this was the most biased trial I had ever been a part of. And he's tried cases in death penalty cases in the Deep South that were much more impartial.
Yeah, all across the board.
And even if there was a new trial, you would also have to look at a lot of issues. For example, is the jury going to be from a particular area? Are they going to be a black jury? 2, who is actually going to testify at the trial? Who will be allowed to testify from all of the prior bad acts, individuals that came there to give that testimony? Are they going to allow 1 or 2 as opposed to like the 5 that they had, etc.? And also the age of the accused too, because by the time that you've got somebody that's incredibly old, a prosecutor can have the right to say that they don't want to try people because it is not in the public interest. So they can make the choice if they would like to try him or not try him. They don't have to.
I also like to add too, because you just said his age, he's about 83 years young. But I also think about the Emmett Till trial where Carolyn Bryant should be in prison right now, rotting.
Yes.
But not in hell, because she's 83, about the same age as Cosby. And she the one that got Emmett Till killed and talked about how she lied about it to the historian Timothy Tyson. But also you look at, they're not going to try this again. I'm gonna tell you why. Because the time has passed. It's a different move now. And the thing about it, you gotta go back to Curtis Flowers. I don't know if y'all familiar with the Curtis Flowers thing. This brother was tried 6 times in the state of Mississippi on circumstantial evidence. He was on death row about 20 years. They just released him last year, right before the holidays or holidays. But he was on trial on circumstantial evidence. They accused him of killing his former boss, Bertha Tardy, and 3 of her employees at Tardy Furniture in Winona, Mississippi. This is the same Winona, Mississippi, where they beat Fannie Lou Hamer to an inch of her life in prison the day before they killed Medgar Evers. So we dealing with the same type of mindset. But I went to his appeals hearing back in 2014 in Jackson, and I talked to his lawyer and stuff like that. But he should never been put in that situation because he was the only person that the prosecutor, overzealous DA, looked at as being a suspect. Although you had other people that could have been suspects. They had a killing spree that summer of '97 when that happened, but they only looked at him. So he's out right now, and they're not going to try him again for a 7th time. I mean, he was on death row for 20 years. He's the real Green Mile. Never had a behavioral problem while he was in prison. All the inmates, for the most part, and the jailers loved him, but they had one guy that was a jailhouse snitch that ended up killing his baby mama and her mother and almost killed his son. This was the prime witness against Curtis Flowers, this jailhouse snitch that should never been let out of prison. So y'all look up the Curtis Flowers case.
Right. And Dru, what were you gonna say? You were gonna say something earlier.
Oh yeah, I was just gonna piggyback what Gavin was saying about the injustices in this case and the little details everywhere you turn. That is just, this case is so corrupt. Even the fact that Judge Stephen T. O'Neill's wife is a sexual assault counselor. The fact that Kevin Steele, he made it his political ambition before Mr. Cosby was even convicted. You can't do that. You can't promise to jail someone who hasn't been convicted. And that was his campaign promise. And everywhere you turn, like, there's just, corruption and with the people involved. And I think Janice Baker Kinney, one of the accusers, I think she brought it up. She admitted, like, before the trial, the story was that, Bill Cosby drugged all these people. She admitted on the stand that she took the drugs herself.
That was something that they brought up too.
Right.
The other thing too, when they mentioned Shalana Lasha, one of the things they should have mentioned is the fact that this woman was a fugitive from justice that was allowed to even testify. Her testimony should not have even been admitted to begin with.
Yes.
Right.
I mean, and she didn't even claim rape. She claimed that he humped her toe.
Right.
Humped her leg.
Her leg. Humped her leg. Dry humped
Like
her
a
leg.
dog. Well, he is a cute dog, I guess, but I mean, damn, they don't get that serious.
Yeah, that lady in particular was so whacked out. And people, this is when you don't do your research. Yeah. This is who you are supposedly rallying for, i.e. Me Too, Time's Up, Silence Breakers. If you don't do your research, this is who you're rallying for. People who just made up anything. And this is what was so dangerous about this whole case. And I feel a little better looking at the justices. At first, I'm like, although, yeah, I wish there was some color up in there, but it is what it is. We're in this system. This is what we got to deal with. But I feel positive. I'm not going to say, oh, it's just straight out, because we know how they get down. Okay. It could seem a certain way and be totally different. But I do feel better, a little bit better.
Yeah, it was clear.
I would also say that. Okay. Sorry, please continue. Okay, so I would also say that that is the issue with constantly bringing prior bad acts in, because of the fact that you may get people that say things which cannot be probed, essentially, because it's difficult to have a trial inside a trial about the issue that they're talking about. So that's why typically in law, you don't even have a lot of prior bad acts allowed unless you have the accused actually testifying. That's when you now say, have you been arrested before? Do you have you done anything of this sort before? And then you bring in the outside actions, etc. You don't typically do that if the accused is not even on the stand, depending on the state.
Nicole, apparently I pissed off some Q dogs that are in the chat. Brian Brown and Squeaky G. Shit. I don't care.
Yeah, come on.
I know a lot of Q dogs.
Well, Steve Harvey. Did Steve Harvey try to stand up for Bill Cosby? He told him back down. I mean, Steve Harvey's a Q dog, right?
Joe Torre.
Yeah, Joe Torre.
Yeah.
I mean, I'm trying to balance it out a little bit.
Thank you very much.
Yeah,
thank you very much, Nicole. I have to go, but thank you very much. Have a great day.
Thank you so much for joining us.
Thank you to the panel as well. Thank you to the panel.
It's an honor, sir. Thank you.
Absolutely.
Thank you, brother.
All right. Well, we'll go ahead and I guess wrap it up for now. Your last thoughts, and then I'll let you guys go because I guess that's pretty much it for now until we hear anything else, and I'll check back with the team to see how they feel. So I'll let you go first, Dru.
Yeah, like we all have been saying what we all noticed. I kind of feel that, you know, there are a few judges who definitely believe in their heart of hearts that, you know, whatever they believe personally aside, he did not get a fair trial. And the questions that they were asking are indicative of that. Like, he did not get a fair trial.
Yeah.
And the questions like, you know, well, why did you need this? Why did you need that? Why did you need these 5 prior bad acts? They realized that the case was so damn weak that they did all this extra stuff. And I think the judges were aware of that, and they were zoning in on that. And I was actually surprised that they were good enough to do that. So I think that I'm a lot more optimistic now than I was yesterday. I think that this was as good as it could be.
Right. All right, Gavin, your last thoughts.
All right. Thank you for having me on, and shout out to the chat and the Qs. Brian said we don't claim Steve Harvey. What your ass say? Yeah. I makes a lot of money to be a Q dog. Thank you, player. I gotta throw in some comedy with that. No, I thought it was great. I thought that, you know, Miss Bogine did a great job. All we got to do is pray and keep Mr. Cosby in prayer. And this is important because it sets an implication for future cases to come. And even one of the justices said that, because if indeed somebody can be prosecuted off things they say in a civil deposition after a DA says that there would be no charges, then we don't need the Fifth Amendment anymore. If that's the case, then there's no right to against self-incrimination or double jeopardy. Hell, what about the Sixth Amendment, right to a fair and speedy trial? Because that was also something that was denied to Mr. Cosby. If you're trying to bring charges against him, you know, you waited 12, 13 years to bring this decision when, in fact, you had the information if you wanted to go after it then. They chose not to. So I certainly think that he has a great chance. I like what they said with regards to the commentary by Ms. Bogine and even the judges. We just got to keep our fingers crossed. And Nicole, I appreciate you having me on as always. And I know you're going to have Andrew Wyatt come on a little later, so I'll be tuning in.
All right. Thank you so much, and you're most welcome. All right, Brother Ron.
Yeah, it's an honor to be on the dais with y'all. I want to thank Sister Nicole for being there from day one, from being real black media, covering the story, reclaiming and countering the narrative like a true, you know, you had a boxing mentality when it came to this. You never gave up. Your legs were strong. You went the endurance, and the marathon continues. So it's an honor to be on this show, to be blessed by your work and your gifts and stuff like that. But I want to say this. Yeah, they were very white and mayonnaise, but it's not about the color of the skin, it's color of character. I'm looking at the character because you have true profiles and courage from curious places. I'm thinking about the Scottsboro boys. Y'all know about Central Park 5. I guess Netflix got to make a movie about the Scottsboro boys for y'all to know about that. That was a real travesty. And it was a judge, an Alabama judge named James Horton, who committed career suicide by setting aside the death penalty sentence for Haywood Patterson, one of the Scottsboro boys, and demanding a new trial. This is down in the deep South, right? And I met some of his descendants, actually. Strong genes, you know. But what I'm saying, I was just to say is that Cosby is not going to get another trial. I truly believe that. He's not going to be railroaded again. They already did what they had to do. He paid for the sins of the people, so-called, you know, predators of the Me Too movement. He was a worthy blood sacrifice for this system of injustices, because no justice is just us. So I think there's a new day because people like Nicole, Dru, and Gavin and others are really leading the charge to try to supply and feed our people with the right information to make the right decisions on things. And it's not over. You know, we're still fighting the war. We could win a couple of battles, but we still got to fight the war. But I want to leave people encouraged because George Washington, you know, the so-called founding father, He lost more battles than he won, and yet he still won the war.
All right, guys, do me a favor. Put your YouTube channels in the name part. Let me lower this banner because there are people asking, what's his channel? What's that channel? So just put it as your name. And guys, I want you to subscribe to all of their channels. Great stuff. I'll give you guys a moment. I don't know if you're able to edit it. I should have just did that, but I was last night, I do my Zumba and I was just like out of it.
You do a lot of work.
Yeah. So y'all make sure to subscribe. And also, please come back because I'm going to have Mr. Cosby spokesperson, Andrew Wyatt, join me 1 p.m. Central Standard Time, 2 p.m. Eastern. I guess that's 12 if you're on the West Coast. No, 11 if you're on the West Coast. So, yes, make sure to subscribe to Dru Story News, Gavin Richard Presents, and We All Be TV. And I got to come on your channel. I've never been on your channel, Dru. I've been on Gavin's, and yeah, I haven't been on Dru's, and We All Be TV. But make sure to subscribe to all their channels. Okay, great.
That's the YouTube channel there, gboot2786.
Yes. I'm giving folks a chance. I thank all of you. And I thank all of you who stopped by, who shared, who liked this broadcast, who donated. I thank you guys so much because I cannot do this without you, without the support of the people. I genuinely thank you. This is very important, not just because it's Bill Cosby. It's because it's us. This is us. Doesn't matter what your title is. You guys saw what can happen in an instant. And we have to be together. We have to research stuff and not be so easily misled by propaganda, lies, mainstream media, whatever. I don't know who else was carrying this today. Probably Court TV. I'm sure CNN maybe, dropped in. But I wanted you guys to be on here because we need our own media where we're telling the truth. So, yeah, that's pretty much it. I'm going to let you guys go. I'm sure you have other things to do. I know some of you have work and all that good stuff, but yeah, just come back if you can. 1 p.m. Central Standard Time, 2 Eastern. Thank you guys so much.
Norm King says, I'm about to get a bunch of hate mail from the Q Dogs. Yeah, bring it on, player. I could shuck corn in one setting with these teeth. Yeah.
Gavin,
I love the Q Dogs. I got Q Dogs that are friends. Don't worry. I ain't worried about that. I stay strapped too. But no, thank you, Nicole. Thank you to the chat. Y'all were great, man. And and I have Ron on. I told you Ron is basically a walking history vault.
But still research me. You can't trust a black man. When you can trust the white folks, you can trust Anderson Cooper. You can't trust me though.
Yeah.
Do your research.
Your research. That's all I ask. Your research.
You're a winner. You was a winner. Player with a WH.
All right, guys. Well, you guys take it easy. Take care, and I'll see you guys soon. All right.
Right.
Mr. Trump wanted to know about my line of suits.
Bye, guys. Bye, Gavin.
B1.
See you later on.
See you. Blessings. Love y'all madly.
Bye-bye.